Good afternoon, ladies and gentlemen. Welcome to Burn the Corporate Fiction. Today, we are going to be getting into the untold history of law. I feel it's pertinent, it's imperative, actually, that people realize why they have not only the right, but the duty to stop asking the government to fix itself and just go ahead and do it. Because, as we're going to see, the system we have today is the same system that they had when we declared our independence from Britain, which really it was the independence from the banks and the merchant oligarchs under an empire that I will name here shortly, that has actually been the enemy of personal liberty and sovereignty since its establishment, right, thousands of years ago. There has been, and there continues to be a concerted effort to undermine not just the individual liberty and sovereignty of the people, but the collective national sovereignty of nations. Every nation has been turned into a national trust, and the intention is to collapse these national trusts into a world trust under the administration of an unelected tribunal of corporate oligarchs who will have everything managed by AI governance. And if that happens, which I do not think it will, that's game over. Okay. I see we got Nate, we got Josh, we got Grammy. Good to see you guys from Scotland, even. That's awesome. That's awesome. All right. So I'm going to get right into this. Let's see here. Let's take a look at the Declaration of Independence, shall we? Just so we can see how this is the same system. So the Declaration of Independence, most people have no idea, is actually an action at law. It's a declaration, right? When you file an action at law, it's generally in the form of a declaration, right? So it's literally incriminating, or indicting rather, the King of England for his crimes against the people of the colonies. All right. And it says right here, these are the primary ones. Okay. For imposing taxes on us without our consent, for depriving us, in many cases, of the benefits of trial by jury. Does that sound familiar? These courts of equity, these administrative tribunals, there's no jury trial. Every time you get called in for a breach of trust and misuse of your motor vehicle, quote unquote, right? It's generally, there's no jury trial. There's no nothing. It's all up to the judge. The judge is paid by the state. The prosecutor is paid by the state. The cop that's a witness against you is also paid by the state, right? None of them have incentive to be honest or forthcoming about the actual nature and cause of the charges against you. And the fact that it's a victimless, it's literally a breach of trust. We'll get into that. So depriving us in many cases of the benefits of trial by jury, for transporting us beyond the seas to be tried for pretended offenses. Once again, very same thing that's going on now. Okay. For abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. This is exactly where we're at today. Right? Yet the people are so pacified by your football and your movies and video games and sex and whatever else that they're literally. So back during this time, people were a lot smarter than they are today, and there wasn't nearly as many distractions. It was much easier to get everyone together and go, "Hey, we need to change this." Right? Today, there's so many distractions and creature comforts, what I like to call the artificial womb. That is the matrix of society, right? Which is all an illusion. It's all an illusion. You take away the corporate state and so many people would perish, right? Because they would no longer have grocery stores to go get their food. They'd have to hunt. They'd have to fish, forage. There'd no longer be indoor plumbing and running water, even though it's heavily, fluoridated and everything else. But still, you wouldn't have that. You have to go find your own fresh water sources, right? There's no heat, and let alone electricity and the creature comforts like television and all that stuff, right? All that goes away, and people are so afraid to lose that they're willing to literally suffer these insufferable abuses. And that's literally what Thomas Jefferson says in this document. He says that men will suffer abuses as long as abuses are sufferable. Right here, it says Prudence indeed will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shewn that mankind are more disposed to suffer while evils are sufferable. See, the elite figured out that if they increase the amount of distractions and creature comforts, that level of sufferability drastically increases as well, right? So anyway, same exact system. That's my point. So let's get into this. How has this been a concerted effort implementing the same exact system over and over and over again into societies, followed by revolutions, and then the whole thing resets, right? And then it starts over again. Well, we have to go back about 1,000 years. Okay, I'm gonna let's see, should I start with the treatise on the American Law of Administration? I may just do that because it's very important. So I have so many tabs open, forgive me. I know, there it is. All right. So right here, like this is a book written by J.G. Warner from 1889. It's called The Treatise on the American Law of Administration. There's literally the first third of this book is case citations where he got all of his information to base this treatise upon. That's why treaties are admissible at law as evidence and law as evidence. So he says that the importance of this division, he's talking about the difference between personal property and let's see, where is he talking about this? Or movable property and movable property. That's immaterial to what he's about to say. It says the importance of this division grows out of, or is at least enhanced by, the introduction of the feudal system into England after the conquest, which put an end to all absolute ownership in land and thus did violence to the principle upon which property rests. So we have to travel about 1,000 years back to England, okay? And I know it's tough for you to understand, like, what does that have to do with us now? But as he goes on to continue to say, he says the feudal system has so thoroughly permeated the common law and so thoroughly given it form and color that neither this nor the statutory systems of England or America can be understood without a knowledge of and a continual reference to the feudal principles. So we have to go back there. And we are going back there. I'm going to explain to you now. For the first 1,000 years after the death of Christ, there's hardly any records about what the law was like. And the reason is because the people of the British Isles saw it as an abomination to write the law down. Why? Because it gave man the opportunity to be deceptive, right? You don't necessarily have to change the meaning of word. Well, you can't change the meaning of words in law, otherwise you'll undo previous laws. But what they do is they change the people's understanding of the words as they're used in common usage, and that's how legalese was created. The words in legalese mean what they have always meant, right? They just change your understanding of it. But anyways, the laws were not written down. The people were self-governing. The courts, they had what was called 100 courts, and it was literally divided into sections of 100 families that were self-governing. And the heads of those families, the men of those families, would get together regularly, recite the law orally, and then settle disputes between the families. And it had jurisdiction over spiritual and temporal, meaning, just material matters. William the Conqueror comes over. Now, here's this thing. I usually don't like to talk about this entity too much, right? Because they are, they're still at it. So you can't talk about law without talking about the Catholic Church. You just can't. There's no way around it. You have to talk about the Holy Roman Empire because they're still the ones behind this today. That's a fact. So William the Conqueror was a Norman, and he came over. He was spreading feudalism throughout Europe on behalf of the Holy Roman Empire. What is feudalism? Well, feudalism is where the government takes absolute control of all the property and then gifts it back out in trust so that they can make regulations regarding the property. And that's the great trick that they figured out how to subvert the law. See, the common law, it doesn't need to be written down. It's not written by men. It's studied, observed, discovered, and revealed. Right? If we take a look at the Heart of Blackstone, which is right here. So the Heart of Blackstone says, we kind of got it zoomed in there, huh? The source of the common law. The common law is grounded upon the general customs of the realm and includes in it the law of nature, the law of God, and the principles and maxims of the law. It is founded upon reason, and it is said to be the perfection of reason acquired by long study, observation, and experience, and refined by learned men in all ages. Nowhere does it say that it was written by man or created by man, because it is not. And I know some of you go, well, common law isn't natural law. Well, actually, common law is natural law as applied to society. It's observing the workings of natural principles and applying them to business, commerce, applying them to societal interactions. And that's why it says it includes in it the law of nature, the law of God, and the principles and maxims of law. Principles and maxims of law are observations that are held to be universally true and without error. They cannot be disputed, right? So the common law does not need to be written down, and writing it down is what undid everything. And since man cannot make law, man had to figure out another way to pull people under his control. And so what they figured out how to do, so since man cannot make law, man can regulate commerce, and then he can control his property. The concepts of trust were born, okay? And it's basically, I'm going to take superior interest in property, and then I'm going to let somebody else use my property, and then I can control how they use that property. And that allows me to enforce my arbitrary rules and regulations as if it were law. And that's what the feudal system was all about. So if we take a look at Blackstone's commentaries right here. All right, so he tells you that before William the Conqueror, this is how important this era is. Right here with William the Conqueror. It's still this today with the digital prison, the neo-feudal system. It's the completion of what William started 1,000 years ago. And the United States, while it was created under the guise of escaping the feudal system, it actually has enabled it. And I'll explain that in a little bit, but it's because of the weakness and ignorance of the people. We'll get into that. So he says, scarce had these northern conquerors established themselves in their new dominions when the wisdom of their constitutions, as well as their personal valor, alarmed all the princes of Europe, that is, of those countries which had formerly been Roman provinces, but had revolted or were deserted by their old masters in the general wreck of the empire. It never went anywhere. It merely went underground. We'll get into that too. But anyways, it says, for whereas before the possessions of their subjects were perfectly allodial. So before William the Conqueror, the English had a allodial title. What is a allodial title? Let's take a look at that real quick. Allodial title. Right? So Copilot's not going to give me the thing. But anyways, it's absolute ownership here. We'll see what Copilot says about it. Allodial title represents the highest form of property ownership, providing landowners with complete control, free from obligations to any superior landlord or government. Okay? Though in modern U.S. law, true, yeah, that's because they subverted it with a neo-feudal system. That's why AI is careful to say that. But anyways, it's absolute ownership, free of any obligation to any superior, no property taxes, no telling you to get a permit to build on your land, no telling you can't drill for a well, fresh water, stuff like that. None of that, right? You can do whatever you want with your land when you have a allodial title. And really all of your property, when you have allodial ownership, nobody can tell you how to use it. No motor vehicle code, none of that stuff. And that's what we're going to get into, how they were able to structure and build the system where they can tell you how to use your property. And it goes all the way back to William the Conqueror, as I was saying. So go back to Blackstone real quick. So they had allodial title, right? Now they parceled out their royal territories or persuaded their subjects to surrender up and retake their own landed property. What happened with William the Conqueror? He came over, he conquered England, said, hey, first of all, I'm destroying your self-governance. We're going to give ecclesiastical matters, which is life, death, which is inheritance, death, marriage, stuff like that. We're going to give that to the priests of Rome. And then we are going to give the temporal matters to judges that are going to basically be my proxy. And that's how he set that up, right? No more self-governance. And then he left for a little while. And while he was gone, Denmark came over, invaded England after William the Conqueror had already conquered it. They stayed there, occupied for a little while, then left. And then William conveniently came back and said, oh, you guys were occupied because I took away your military law. That must have sucked. Well, look, I have this new style of government that we've been doing all across Europe, and you guys might want to adopt it so you can stay safe. That was feudalism. So what did he do? Now remember, they had a allodial title. So all these Englishmen registered their land. That word is so important, register. Regis means of the king. Okay, if we go to Google Translate, watch. Google Translate, right? And you put in Regis, of the king. Okay, so register is to give to the king, right? Regnatum means to reign, right? But then if you switch it around, you go like this. If you go English, because this thing is a little wonky sometimes, but you go English to Latin. Let's see, where's that? Hijkl, right? Down here still. There. All right, watch this. So if we go to be governed, because Latin's a symbolic language. So it's regi, right? Regi. So register is to give over the controlling interest to your property. And that's exactly what the English did, was they gave over controlling interest to their property by registering in a land survey book called the Doomsday Book. Okay. And then right here where it says surrender up, that's the registration, then retake their own landed property under like feudal obligations of military fealty. So they literally gave their property to King William, then King William turned around and gave it back to them under title, and he kept the superior interest. Now since it's all his land, he can tell people what to do on his land. And now he was able to create the feudal system, which was essentially just the regulating of property held in trust in a feudum, right, under administration of the crown. And so that went on for a while. Then, because he gave the ecclesiastical matters over to the priest class, what inevitably happened was the priests started screwing the heirs out of their inheritance. And so basically, because right around the same time that he conquered England, the Crusades started. I think it was in the late 1000s, early 1100s, the Crusades started. So all the Englishmen started to go off and die in the Holy War. As they would die, and if their heirs were not of age to take over the fief, the title, right, then the estate would come under administration of the priest class, right, which is the ecclesiastical court. That's what they still are today. That's why they wear the black robes. This is all just one big system of probate or ecclesiastical administration. That's all it is. That's all they've done. They've just expanded the system worldwide. And I'm going to get to that, right? So how do you know, LJ says, how do you know none of them were prior to 1066? What do you mean none of them were prior to 1066? Well, I can tell you, yeah, so Priscilla says that would make sense with the birth certificates, screwing them out of their inheritance, but I wonder what you can do if there's no birth certificate in the state. I actually have a case to show you guys in a little bit, the Abigail Jordan case. I did make I made a short out of it, or reel, whatever, on Facebook. It's real, YouTube, short, whatever, same thing, short video on it. And the case is really quite something. The lady didn't have a birth certificate or social security number, specifically because her parents knew that, well, they thought it was the mark of the beast from Revelations, and to become enumerated by the government is a sin against God. In the court, and she was trying to get a passport because she said her religion called to her to evangelize. I have the Abigail Jordan case, I think is right here. It's a little off topic, but we can take a look at it for a second, then we'll get back into it. So this is the Abigail Jordan case right here, Abigail Michael Jordan v. Marco Rubio. And so she was trying to get a passport because she says her faith called her to evangelize, spread the word, and she could not do that without a passport. And the passport or the Department of State wanted her to supply them with a birth certificate. And if she did not have a birth certificate, which she did not, they needed a letter of no record from the Virginia Bureau of Vitals and Statistics. And Virginia wouldn't give her the letter of no record because they said there was a partial record. When her parents at the hospital refused to register her and get a birth certificate, they the hospital, so they could still collect the money, right, they went baby girl Carmichael, and they created a partial birth record and filed it with the Virginia Bureau of Vitals and Statistics. And when that came out, oh man, basically they did what she wanted so that they didn't get sued. But anyways, the court never once questioned the fact that she didn't have a birth certificate or social security card in this case, right? Here, I can, on the YouTube side anyway, because it's the only one for some reason StreamYard actually puts comments into, I can put this case so you guys can check it out. And then I'll just add it to the Facebook and Rumble. I'll add it to the comments later. But anyways, never once questioned the fact that she didn't have a birth certificate or social security card, not once, and didn't even question the beliefs behind it, and instead upheld it all and forced the Department of State to issue her a passport immediately. This is a huge landmark case. And since her now it's in the district court and it could be overturned as it goes through the higher courts, and the bar pirates are obviously deeply opposed to this type of, case law. But as it stands right now, and the fact that her purpose for getting a passport was evangelizing, it stands to reason that anybody who adopts the same beliefs and attitudes and understandings that she has have the right to extricate themselves from enumeration and registration and get rid of your social security number and your birth certificate. That's what this case actually does. This case isn't so much about getting a passport without those things. This case, it is that, but even more so, it establishes precedents that holding those beliefs that enumeration is a sin against God, which it is. It's 2 Samuel 24, where David takes a census and then a plague comes and wipes out 70,000 people because he enumerated the people. And that's how satanic and deep this system really goes. But this is present time stuff. I was going to get to this more towards the end of the stream. We will circle back to this, but I want to cover this stuff over here first with Blackstone. So anyways, they registered their land with William the Conqueror. Then William gave it back out under title, and now he could actually enforce his will as if it were law, So you're welcome, Priscilla. And so he can enforce his will as if it was law, because he's now just regulating property under his administration, which is something man can do, right? Man can't just arbitrarily make law and enforce it on just anybody, but they can control what's done with their property. And that's why J.G. Warner over here, like we were just saying, I think it right here, he says, the feudal system has so thoroughly permeated, because he's talking about William the Conqueror right here after the conquest. The feudal system has so thoroughly permeated the common law and so thoroughly given it form and color that neither this nor the statutory systems of England or America can be understood without a knowledge of and continual reference to the feudal principles, because that's exactly what we supposedly established this country to get away from and have free allodial title, right? Because look, I'll show you right here. First, we got the Wisconsin Constitution from 1848, right? And 1848, Article 1, Section 14 says all lands within the state are declared to be allodial and feudal tenures are prohibited. And if that's not enough, because I know it's a grainy photocopy, we've got this little document right here. This is the report of the Commissioner of the General Land Office to the Secretary of Interior from 1870. And he says right here on page 28 and 29, pages 28 and 29, the individual title derived from the government involves the entire transfer of the ownership of the soil. It is purely allodial, with all the incidents pertaining to that title as substantial as in the infancy of the Teutonic civilization, which is where allodial comes from, by the way. Following in the wake of this fundamental reform in our state, blah, blah, blah. And it goes down here, it says the statute of uses was never adopted, which is feudalism, in the public land states, and hence the complex distinction between uses and trust has never embarrassed our jurisprudence. It's huge. That's how we were literally set up in the beginning to prevent this. And there's so much fraud, coercion, collusion, misrepresentation of material facts that's taken place that even though they've now established neo-feudalism again, it's a house of cards. It's such a fragile system. For instance, you take out the 14th Amendment and it all goes away. It all goes away. And we're going to get to that. And I'm going to speedily go through the old history of England until we get to the United States, because I'm sure that's what many people are interested in hearing about. And there's a lot of deception that happened at the start of this country. It's the Constitution is not what you think it is. So Anyway, feudalism was established and then it was developed. And that's where equity came from. Okay, I'll show you that. Equity comes primarily from feudalism. It's Roman civil law. Roman civil law is pure commercial equity. Okay, there's no law, actual law in Roman civil law. It's all just military conquest, feudalism. That's it. So we'll take a look at Roman civil law, feudalism, equity. So we want to go to the commercial equity. Where was I going with that? Oh, yeah, the use of the trust. Yep, that's it. So we want to go to Practical Treatise on the Law of Trusts and Trustees. This is a fantastic book also with tons of citations in the beginning, right? And that's why, again, treaties are admissible as evidence in law. So he says the origin of trusts, or rather the adaptation of them to the English law, may be traced to the ingenuity of fraud. By the interposition of a trustee, the debtor thought to withdraw his property out of the reach of his creditor, the freeholder to intercept the fruits of tenure from the Lord, and this is most importantly, and the body ecclesiastic to evade the restrictions directed against the growing wealth of the church by the statutes of mortmain. So basically, King Edward, the very one from Braveheart, you know, the one that's the bad guy in Braveheart, right? Well, I'm sure he was a kind of a dick, but at the same time, he had a good legal mind. And he saw what the church was doing. Basically, people were dying and giving their land to the church. And what's the problem with that? Well, the church never dies. The church doesn't have heirs, it has successors. So eventually, over a period of time, the church would usurp all the land. It's inevitable. How could it not be? Once it gets into the hands of the church, it never leaves because the church never dies. So he issued the statutes of mortmain and was like, yeah, no more dead hand ownership. And then the church got around that by creating trusts. And the trust would hold the land for the benefit of the church, right? So anyway, he goes down here. He says, originally, the only pledge for the due execution of the trust was the faith and integrity of the trustee, but the mere feeling of honor, proving as was likely when opposed to self-interest and extremely precarious security, John Waltham, Bishop of Salisbury, a chancellor in the reign of Richard II, originated the writ of subpoena, literally where subpoenas come from. And if you're being subpoenaed, you're a trustee. If you were being summoned, right, as they call it now, this is the origin of a summons. If you're being summoned, you're actually a trustee who's dead to the law. So now you actually have to be summoned into court from beyond the grave because you're civiliter mortis, or civilly dead, right? And so anyways, the writ of subpoena, and it says right here, by which the trustee was liable to be summoned into chancery, which is now equity, but originally in Michigan, it was still called chancery, and compellable to answer upon the oath the allegations of his set decay trust. And that's what they're doing when they summons you to court. They're summoning you to court and compelling you to answer upon oath the allegations of the set decay trust. Why'd you misuse this property, right? You hold this property in trust. Why'd you drive it faster than we've prescribed in the regulations? Why is that, right? You violated the trust. You are now being summoned into chancery and being compelled to answer upon oath the allegation of the set decay trust. That's all that's taking place now. He goes on to finish this. He finishes saying, he says, thus, in the words of an old counselor, the parents of the trust were fraud and fear, and a court of conscience was the nurse. A court of conscience is a court of equity. Law is not equity, and equity is not law. And when they claim to have abolished the distinction in 1938, that's impossible. They never could. It's a very deceptive way to describe what they really did. What they really did was they barred your access to law. Because in order to have access to law, you have to have lawful rights to something. In order to have lawful rights to something, you have to be able to buy it. And in order to buy it, you have to have access to money. And if you do not have access to money, then you do not own anything. And guess what? You have no access to money. You have access to debt notes. And guess what? Those debt notes are secured by the mortgage of your property rights. So you literally cannot own anything because the very thing you think you're quote unquote buying things with represents your trust indenture, your slavery. You are what secures. They go, well, they just print money out of thin air. Sort of, except for there's security, and you're the security. The ability to control you is the security that backs the Federal Reserve. The ability to tax you and generate revenue from your misuse of trust property is what secures the Federal Reserve note. So you're sort of right when you say they printed out of thin air, but they needed two things. They needed surety. They needed property to be surety, which is you, right? The public 14th Amendment chattel. And they needed insurance. And it's really the insurance companies who underwrite this whole thing. So what they do, contrary to what people think, is when you're born, they do mortgage your estate. That's stated in congressional record. We'll look at that in a little bit. House Congressional Record, March 9th, 1933, page 83. They definitely say that they mortgaged your estate. But not just that. What they do is they take out a life insurance policy against you, and then they borrow against that. Because they have administrative control of your estate, they take out a life insurance policy against you when you're born, and then they borrow against that. And it's the insurance companies, the underwriting insurance, they're the ones who are really behind everything. They're even more powerful than the banks. The system couldn't exist without them. So, all right, let's get back into the history. So the parents of the trust were fraud and fear, and a court of conscience was the nurse. And well, now that we've gotten into equity, let's talk about the difference between law and equity. Let's take a look at what Blackstone says about equity, right? So we go down to page, in this copy, it's page 59. So let's see, that's definitely way past 59. 84, 50. There we go. All right, so he says right here, he's talking about equity. What is equity? Well, equity deals with things that are not, that law cannot deal with. And the reason that trusts can only be adjudicated in equity is because trusts are fictitious legal persons. When you're dealing with the trust, at law, it's treated as if it is an entity of its own. Like that trust is the person. You cannot say the trustee holds the property. It's the trust that holds the property. And the trustee acts as sort of like a bodily limb of the trust to accomplish the ends of the trust, right? But the trust itself is a legal fiction, is a legal person. And law cannot recognize that because law only deals with what exists in fact and what has happened. It cannot deal with what might happen in the future, and it definitely can't exist with artificial constructs of the mind that have no existence, in fact. So that's why equity rose in prominence. Originally called chancery, there's really very little difference between chancery and equity. So much so it doesn't even bear mentioning. Now, with that being said, equity deals with fiction. Because it deals with fiction, the judge has godlike powers. Because he's not adjudicating living souls. What he's adjudicating is fictions, creations of man. He's not dealing with creatures of God. He's dealing with creatures of man. Therefore, man can act as God. That's the legal logic behind the judge's power and equity, right? Bouvier calls it the law of tyrants. We'll take a look at that momentarily. But, and this is why Blackstone warns against abandoning law for equity. Okay, he says, and on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest thereby we destroy all law and leave the decision of every question entirely in the breast of a judge. And law without equity, though hard and disagreeable, is much more desirable for the public good than equity without law, which would make every judge a legislator and introduce most infinite confusion, as there would then be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. See, because man does not write law, man cannot change law, man cannot alter the process of law, okay? And so, but in equity, they literally have autonomy to do whatever they want. And that's dangerous. And even Blackstone warns against it. Now, equity can be useful. It has its place, like in adjudicating implied contracts and adjudicating things that law just can't look at. Like say you have a ship and the ship's going down and it used to be the law, right? Like he actually uses that exact example right here. He says, where is it? There was a law that those, and this is from Cicero, actually. He says, there was a law that those who in a storm forsook, the ship should forfeit all property therein, and that the ship and lading should belong entirely to those who stayed in it. Well, that would have to also be handled in equity, right? Because there's no actual agreement. There's no actual agreement between the parties that, like, hey, if I jump off the ship, you can have my property. There's nothing in writing, right? You're just merely going off conscience, which should be equitable, which should be right. Well, we stayed on the ship. If we didn't go off the ship, or if we jumped off the ship also, all the property would be lost. So technically we should have this property because it's only here because we saved it. But there's no formal contract conveying the rights of property from the current owner to the other people who stayed on the ship and saved the property. So law would never enforce that, but equity will. Okay. And that's what he means by hard and disagreeable. Law is black and white, cut and dry. Did this person of his own free will give you this property or sell you this property? No, you're just interpreting that you should have it based on moral conscience and that's how it should be, but there's no actual agreement. Then no, we can't enforce that. It's not a thing. I'd be like, and I use this in the Juris Society, this example all the time. It's like if you're out of town and your house catches on fire, I live across the street from you and I come and I put your house out. Right. And then you get home and you go, man, thanks for saving my house, dude. That would be like, yeah, dude, well, that's my house now. What? Well, that house wouldn't be there if I didn't save it. So it's my house now. Same concept. Right. So he goes on to say, this is why each instance in equity is supposed to be different. And there's no rules of procedure laid down and that's why the judge has so much power. He's supposed to determine by his conscience, by what he deems to be morally right and wrong. And we know how dangerous that is because these judges are generally Satanists with serious God complexes. And they always have been. Not all of them. There have been some good justices and some good judges, like Justice Mahoney from the Credit River decision, right? Jerome Daly case. Maybe we'll take a look at that today if we have some time as well. But he got killed. He got killed because Jerome Daly, his home was being foreclosed on by the First National Bank of Montgomery. And he said, hold on a second, this entire contract is void. And it was right when Nixon took us permanently off the gold standard, right? And he said, I believe it was like 1969. It was around the same time. And he says, hold on a second, this contract's not valid. Said, you didn't give me anything of actual consideration. I put up this land, this house, and you gave me nothing but my own credit, right? So this is null and void. And Justice Mahoney and the jury agreed. So Justice Mahoney, because Justice of the Peace doesn't actually have any power in common law, he's more like a referee, and that's how it's supposed to be. But the jury upheld it, and the justice gave an opinion, or Justice of the Peace gave an opinion on it, and was like, yeah, absolutely. Only God can create something of value out of nothing, right? This is not action. None of these contracts are valid. Boom, like half the jury and Justice Mahoney died. So, not saying they were killed or anything. YouTube, Facebook. I'm just saying. It's pretty convenient that they all died. We'll get to that, hopefully. Anyway, so yeah, he says that says we would destroy all law. Well, guess what? When they abolished the distinction in 1938 between law and equity, right? They actually just barred your access to law by locking you in a trust relationship with all of your property, including your own children and even your own body, by mortgaging your estate to an international banking cartel. And so they didn't abolish law. They barred your access to it. And they say they abolished the distinction. They did not really abolish the distinction. They just merely moved everybody into pure commercial equity, which is Roman civil law. Roman civil law is pure commercial equity, where the judge gets to be emperors, right? And that's why the Bar Association likes equity so much. So now let's get into the basis of law real quick before we start talking about the United States. We're going to go up here to the very beginning of this book, and this is a fantastic book. Again, this is a treatise on the American law of administration. All law, well, quote unquote law, this actual system of equity is pure administration. That's what administration is. Administration is essentially a charitable trust situation where the state is charged with looking out for the well-being of someone who is declared to be incompetent and not have free will. That's what administration. So you're talking minors, you're talking And they do consider you a minor under 31 CFR and Title 1, Section 8 of the United States Code. You're considered an infant and a minor. And a pauper, right? Again, paupers come under administration because they cannot take care of themselves, so they have to apply for benefits. And so the administrator has the right to take control of the estate and say, well, since you couldn't make yourself productive, we're going to tell you what to do and how to use your property and make you productive. And then we're going to take a snippet of your productive value and give it to you in the form of benefits. And we'll take a healthy administrative fee for our troubles as well. And that's just purely what administration is. And it's always been carried out by the church, always. Like the word minister is right in the word administer. It's literally the whole word. Just add minister, right? So anyway, let's see what J.G. Warner says here. In order to talk about administration, he has to talk about property rights because all law revolves around property, all of it, because property is the ultimate realization of your free will. So law could be said to protect the free will, which is the most sacred gift from God. And all of your rights are derived from your property. In Latin, the word for estate is status. And a person's status, everybody knows, oh, fix your status, correct your status, right? And all that. Well, does people have no idea what that word means? Your relationship to your property, your ability to use it. You have absolute ownership and unrestricted use of your property, or are you told what to do with it and does somebody else have an interest in it and charge you to use it, right? That determines your status. Your relationship to your property determines your status. And in the beginning of this country, we were sovereign. And I'm going to prove that to you here momentarily when we get into the United States. But he says, my property is that which is mine. That only is mine, which I acquire, hold, and dispose of by my will. It is my will which determines the acquisition of a thing by me, whether originally by reducing to possession and making my property that which was no one's property before, or by contract, by which a thing becomes mine through the concurrence of my will with that of its former owner. And see, the understanding of free will being the source of law and property being its realization is the ultimate foundation of contracts. Contracts represent a concurrence of will, an accordance of will between two people to have an exchange of property. And without that contract, whether it's verbal or written, you cannot take possession of something someone else has, or you violate their free will. All crimes are a violation of free will. Actual common law crimes are violations of another's free will and could be said to be properly theft. Okay? If you assault somebody, you have violated their free will to not want to be touched, obviously, or harmed, and also stolen their autonomy. If you kill them, you violated their right to life. Right? You've stolen their life and violated their free will to live. Okay. And then stealing, obviously stealing, and you can go down. And that's why thieves under the common law are treated so harshly. They used to hang people for stealing cattle, and you didn't get a second chance, and it didn't matter why you did it. And that might sound harsh and disagreeable, like Blackstone says, harsh and disagreeable. But it's better for the public good than equity, where you can make up a myriad of excuses of why people did stuff, let them go 25,000 times, and then they, kill somebody. So anyway, it says, he goes through that. He says this right here. He says, I hold or use a thing which is mine at will. Matter is unfree. It has no will. It does not belong to itself. And that's why when they reduce you to property, you are unfree and you're considered not to have will. So incompetents, infants, paupers, they all basically become chattel. They become matter. They become unfree without a will. Even if they try to express one, they're considered to not have the capacity to use it responsibly. So the law recognizes the need for a caretaker and then recognizes administration. Though administrative regulation is not law and cannot be adjudicated in courts of law, it has to be equity because it's a trust. But law still acknowledges the validity of the administrative system. And that's what they've capitalized on, right? So let's see here. He says neither right. So he says matter is not unfree. It has no will. It does not belong to itself. Neither right nor duty can be predicated of a mere thing. Its quality is to offer resistance. It is therefore negative to my will. My will, in realizing itself, overcomes this resistance and subjects the thing to its purposes. changing its form, destroying it, consuming it, and infusing it with your labor, your creative essence. That's why property is so sacred. And it truly is the ultimate realization of your will. And it says, that which is mine is thus part of my personality, of me, insofar as its end and purpose of existence is the satisfaction and the realization of my will, and to serve it for its purposes as my bodily limbs serve me. So what are we taking from this, right? What we're taking from this is if somebody else has a superior interest in your property and can control you and tell you what to do with your property, including your children and your own body, then they have stolen your free will. And that is entirely antithetical to the principles that created this nation. Every nation. As Thomas Jefferson said, governments are only instituted among men to protect those sacred rights. And those rights are property rights. It's all property rights. So it says alienability of property. We'll go down here a little bit. He says, property, then, is the realization of the free will of a person, the external sphere of his freedom. As such, it partakes of and is clothed with the dignity and inviolability of the person. The things which constitute property can have no rights, for they have no will, and will alone, or the person in which it has its abode and vehicle, can be the subject of a right and its correlative duty. The law recognizes and deals with property only insofar as it recognizes and deals with the will of the owner, realized or externalized therein. And that's really the basis of all law, right? What is your will in regard to this property? And the law is there to protect your will in regard to the property. And the property is not just things you acquire, it's things you're born with, your mind, body, soul, the things you create, your children. What is your will regarding these things? And when the government or anybody has a superior say in what you do with your property, you're a slave. There's no other way to put it. And so it says, for the sphere of the law is the spiritual. It operates upon and through the will alone. And that's why I say all law is spiritual. The study of law is a spiritual study. Okay? So now that we know what property is, we know what law is, let's start talking about this country. So as we see in this Declaration of Independence, right, there's a whole list of abuses, and they're pretty much, we could actually apply this very same Declaration of Independence right now, because the same abuses are happening because it's the same people that we fought to get away from in 1776 that are still trying to enslave us. They've been doing it for over 1,000 years. And now they're almost there with AI governance and digital ID. If people accept that, it's permanent. They've won. That your trust indenture will be integrated with your body, and the AI will only ever see the legal fiction. And there'll be no due process, no opportunity to challenge jurisdiction. You go 5 over the speed limit, and your smart car notifies the AI governance, and $200 immediately deducted from your digital wallet. No due process, no, state your name for the record, and you can appear by special appearance and challenge the nature and cause of the charges against you. You can do that now. That's why they want to set up AI governance, because then no, that's gone. You won't be able to do that anymore, right? So anyways, he says right here, he has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. He's talking about administrative law. That's what they did. They brought admiralty inland and set up administrative law just like they have today. And that's what we fought this war against, what they fought this war against, right? So he says in other parts, like they've gotten rid of juries, right? So where's that at? Cut off trade for imposing taxes on us without our consent. For depriving us in many cases of the benefits of a trial by jury. Traffic court, anybody? Family court, anybody? Right? For transporting us beyond the seas to be tried for pretend offenses. Ring any bells? Anybody? Are we seeing this? Right? So this is exactly where we're at today. Well, now, this is the interesting thing. We fought the revolution. We won the Revolutionary War, and we became independent. We're going to take a look at Chisholm v. Georgia. Now, realizing that all law regards property and your right to property, and whether or not somebody can tell you how to use your property, it determines your status. This is why we have allodial title. At the Revolution, the sovereignty, this is Chisholm v. Georgia, 2 U.S. 419 from 1793. It says, at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of this country, but they are sovereigns without subjects, and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Now people go, well, yeah, the people are sovereign collectively, not individually. That is one of the dumbest statements anybody could ever make. How does that make any sense? We only have collective sovereignty. So if we're sovereign and the government's not sovereign, but the government represents our sovereignty, or the government represents us collectively, but they're not sovereign, yet we are collectively sovereign, then how are we not individually sovereign over the government? Well, he actually goes on to say here, from the differences existing between the feudal sovereignties and governments founded on compacts, now we understand what feudalism is, right? Where the government has centralized control and the controlling interest in all property, right? Basically, it's a big national trust system where all the citizens are reduced to trustees, holding property in trust and subject to regulation. That's feudalism. So he says, from the differences existing between feudal sovereignties and governments founded on compacts, it necessarily follows that their respective prerogatives must differ. Sovereignty is the right to govern a nation, or state sovereign is the person or persons in whom that resides. In Europe, the sovereignty is generally ascribed to the prince. Here, it rests with the people. There, the sovereign actually administers the government. Here, never in a single instance. Our governors are agents of the people, and at most stand in the same relation to their sovereign in which regions of Europe stand to their sovereign. Now, what does that mean? They are our subjects. They are actually indentured for a term of service, right? They're indentured for a term of years, basically. And that's why we call their terms. And that's an indenture. They're subject to us, okay? Got another case here. It's Kemper v. State, okay? It says, under the laws of Great Britain, the king is the sovereign in whom is lodged all power. He rules over his subjects by alleged divine right, and his subjects enjoy no privileges and possess no rights except those which the sovereign king sees proper to grant them. And he goes on down here to say, the rule in America is that the American people are the sovereigns, and in them is lodged all power. And the agencies of government possess no authority save that which is delegated to them by the people in the written compact entered into between the people, which is styled the Constitution, and the laws adopted by representatives of the people in the legislature assembled. So here's the thing, and people really have to look at this properly. The Constitution doesn't give us rights. Our rights are inherent, right? They're granted. Like we don't need our rights written down. We are the creators of government. Okay, so the constitutions of the states and the federal Constitution actually delineates what portions of our sovereignty we're going to let them borrow, and they literally can do nothing that's not written in the Constitution to do. Well, they've stepped all over that, haven't they? And one of those things is definitely our property rights. They're not supposed to legislate against our property rights whatsoever. No income tax, no property tax, none of that. It's antithetical to this Constitution. If you get charged a property tax by your county or state, that is a feudal tenure. The county, the state, acts as a corporate feudal lord, charging you an annual fee to be a tenant on the land. And that is antithetical to allodial. And I just showed you guys earlier that we have allodial title 100%. It is right here. This is, if we go to the title of this, and I'll show you guys just so you can see the title, will probably be a little bit more impactful for you. Okay, this is an actual government record. And it is, well, it loads. Sorry about that. All right, there we go. It is the report, the annual report of the Commissioner of the General Land Office made to the Secretary of the Interior for the year 1870. Now, the General Land Office is what the BLM used to be. Okay, Now the BLM is an administrative agency that's basically regulating feudal tenures. So we'll go down to page 29 once again, because I know we got new people have joined us since I just showed this last time. All right, whoops, that's way too far. 36, 31, here we go, 30, 29. So it says right here, and I'll zoom in real good for you guys. The individual, oops, this right here. The individual title derived from the government involves the entire transfer of ownership of the soil. It is purely allodial, with all the incidents pertaining to that title as substantial as in the infancy of the Teutonic civilization, which is where allodium comes from. Allodial comes from the Nordic word, the Germanic word othala, which means ancestral inheritance. Your absolute right to have dominion over land that goes all the way back to, well, the first man and woman. That dominion granted by God. And so it is your ancestral inheritance to have absolute dominion over land. Not necessarily ownership, but as far as everyone else is concerned, it is absolute ownership, because no entity or individual can have a superior claim to it. The only entity that has a superior claim to it is God. And that's the only reason, like, obviously, you can't truly own land because it's not ours to own. But as far as everyone else is concerned, an allodial title is absolute ownership, right? Because only God has the right to take it away from you. So we have allodial title, and that's why, because we are the sovereignty. If we were not, so if we were sovereign but did not have allodial title, then you're not sovereign. You're a subject to the feudal lord, because then you're going to be a tenant on the land and you're going to be told how to use your property, and that is the exact opposite of sovereignty. That is the exact opposite of sovereignty. So you're not sovereign, or you are sovereign, but you couldn't be without allodial title. That's what I'm saying. So right here, American people are the sovereigns, Chisholm v. Georgia. Right here, the sovereignty devolved on the people, and they're truly the sovereigns of the country, but they're sovereigns without subjects. And that's why you have absolute property rights. Well, that was never intended to be permanently the case. And we'll see as we get into the Constitution. Now, everybody likes to talk about the Constitution like it's the great safeguard of our liberty, right? But the Constitution is actually a subversive and deceptive document. Originally, the Articles of Confederation, which we can take a look at real quick, were fantastic. So great, it makes you wonder why they replaced them. I'll explain why, because let's take a look at a couple of these provisions. Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this confederation expressly delegated to the United States and Congress assembled, right? That's good. So they enter a confederation is where states retain their sovereignty. It's the opposite of a corporate union where all states are subdivisions of a corporate headquarters. That's what we are now since 1871. But we were still a confederacy all the way up to the Civil War. Like, even though we had the Constitution, it supposedly replaced the Articles of Confederation, all the states were still Confederate. I've got a revised statutes from Michigan where they talk about how solicitous they are to give proof to her sister states and the world her unequivocal desire to promote the peace and tranquility of the Confederacy. And it says it right in 1846 when they acknowledged their acceptance into the Union. So we are, and all Confederate means is that the sovereignty resides within the state. It's its own country. All of our states are actually our country. People ask me in comments all the time, what if I don't want to be a United States citizen, what do I want to be? Well, what state do you live in? Oh, I live in Michigan. Then you're a Michiganian. It's literally your nationality, right? I've got this list here, and then we'll get back to this article of Confederation. I just thought of this. I've got this, see if I can pull this up. This right here. These are nationalities. This is from the Government Printing Office Style Manual. Okay, these are your nationalities. Alabamian, Alaskan, Arizonan, Arkansan, right? Californian, Coloradan, so on and so forth. These are the nationalities. Because we are a Confederate Union and each state is actually its country. What do they call the department of the federal government that deals with foreign nations? The Department of State, because that's what a state is. A state is a country. Okay? So Anyway, this right here, Article 4 of the Articles of Confederation, the better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants, which are called state nationals, of each of these states, with paupers, vagabonds, and fugitives from justice excepted, meaning they're not included in this, shall be entitled to all the privileges and immunities of free citizens in the several states. So what does that mean? You didn't even have to be a citizen. You could be a citizen if you wanted to participate in government. If you wanted to hold office, you had to be a citizen, but you didn't have to be a citizen to enjoy all of your common law property rights, your absolute allodial ownership. You could be an inhabitant. Well, they didn't like that too much, right? Here's another thing they didn't like. For the more convenient management of the general interests of the United States, delegates shall be annually appointed in such manner as the legislature of each state shall direct to meet in Congress on the first Monday of November in every year, with a power reserved to each state to recall its delegate. Think about that. So they had 1-year terms, right? They were just called delegates to the United States and Congress assembled. Okay, so they were congressmen. They had 1-year terms, and they could be recalled at any time for any reason and replaced. No freaking nursing home in Washington, D.C., right, where you have these decrepit PDF file zombies haunting the halls of the Capitol building. There's none of that under the Articles of Confederation. But most importantly, of all the things that this Articles of Confederation did, right, this right here, retaining its sovereignty, freedom, jurisdiction, and right, each state. There was no federal judiciary. There was no superior judiciary to the states. There was no superior judiciary. So how did the Constitution come about? Well, about 10 years after the Articles of Confederation were put in place, all the wealthy people got together at a constitutional convention to discuss changing the Articles of Confederation or getting rid of them altogether. Now, they waited till Thomas Jefferson went on a diplomatic mission overseas to France, and because he was utterly opposed to such a thing, Patrick Henry refused to attend the convention because he said he smelled a rat. He knew what they were doing. So many of the found George Mason opposed it, and they all primarily opposed it because of the introduction of the federal judiciary. That would, and we're going to read some quotes on that. And we can see the havoc that it's wrought today. You have a Supreme Court that can declare what is constitutional and what isn't. And often they declare things to be constitutional that are in direct contradiction to the common law and the Constitution. And we see that, right? So anyway, so they were opposed to it. Thomas Jefferson was out of town. They got together and they said, well, if the common people are able to unite in a common interest, then the interests of the minority won't be taken into consideration. This is what James Madison said about it. It's in Eliot's Debates. I didn't pull it up today, but I've shown it before. Eliot's Debates, volume 4, I want to say. And he says the interest of the minority won't be taken into consideration. Basically, they won't be able to be a bunch of rich scumbags and screw people over, because as soon as they start pulling their horse crap and turning people into chattel property, it's very easy for the people to unite without a centralized government. When the strongest power of government is in small pockets spread out throughout the nation, it's very easy for the people to manage the government. If the highest executive office in your state is your county sheriff, and nobody can come into that county, not even the president himself, and override the executive authority of that sheriff, you only ever need to worry about whether that sheriff's doing what he's supposed to do. And because that you all have common interest in that community, you're all probably a tight-knit community. You know each other. That's how it's supposed to be. You know your families, your kids play together, all that stuff. Then if the sheriff starts getting tyrannical, it's very easy to either get him out of office or string him up. Very easy. And then you just get a new sheriff. That's why it was set up originally as a Confederate republic, because then the people could very easily manage their own communities. And that's the highest power in the land, is just your community. That's it. So the federal judiciary, they decided to scrap the Articles of Confederation because it didn't provide a strong enough central government. And like I believe it was Patrick Henry, he said, how can you accuse the government that's seen us through a war with the strongest empire in contemporary history. Well, how can you accuse it of being incompetent? Basically, not verbatim, but something to that effect. He's like, no, there's some other reason you guys want to do that. And there was. And it was to leave the back door open for the Bar Association to take our sovereignty. And that's exactly what's happened. Okay. Because even after they established a federal judiciary, you didn't have to be a bar member to be a lawyer. Right. And in fact, we don't even have lawyers anymore. We have attorneys. And attornment, are basically middlemen that just transfer homage and service, right, from one lord to another. That's all they're doing is attorning your homage and service to the court. They're not even lawyers. They're attorneys. A totally different class of legal professional. It's called attorney, right? Well, we might look at them here shortly. I've shown them many times, though. Well, do I have it already pulled up? Yeah, I do. Look, attornment, the act of a feudatory, vassal, or tenant by which he consents upon the alienation of an estate to receive a new lord or superior. Basically, when you hire an attorney, he has the power of attornment over your estate. That means your rights, your loyalties, your duties. He has control of them. That's why they always want you to get an attorney so you become a ward of the court. So let's take a look at what Thomas Jefferson said. Well, first, here's one more thing, how we're not a democracy. This is a pretty good article. Why the Founding Fathers Despised Democracy. Says, let's look at a couple quotes. The founders inherently understood this and wholly rejected democracy. Democracies have never been spectacles of democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, because democracy automatically, it's a slippery slope right to communism. All democracy is communism light. It's the enslavement of the minority by the will of the majority. And it does not take into consideration personal property rights, which is what law is, right? So in order to actually have a democracy, you have to have reduced everyone to trustees in a national trust, basically like members in a membership corporation where the administrator, like the executive power of the corporation, can redistribute property at will between the members. That's what democracy is. Does not, and that's why I said it has ever been found incompatible with personal security and rights of property. Absolutely. So that was James Madison. And Madison says also that this same erroneous belief held by collectivists destroys property rights, which is foundational to any free society. That's why I've been talking to you guys so much about allodial title and what it means to be sovereign. What it means to be sovereign is you have autonomy not only over the property that you acquire and hold, but you have complete autonomy over yourself and your family, like your children. Okay. So that is one thing I can actually credit Madison for, but we're definitely not a democracy. We're not supposed to be a democracy. You could not have a democracy under our original common law republic. They needed the 14th Amendment to be able to create a democracy. That's what they had to get that done, because that 14th Amendment is a creature of the federal corporation and is a trust office under administration as a ward, because it was created for newly freed slaves, right? Who, because of their dependency and servility, having been enslaved for generations, they did not yet know how to operate in the common law institutions and take care of themselves. Okay. And maybe not all of them, but most of them. That was the generalization. So they would automatically come under administration anyways. And so they capitalized on that, and they created basically a citizenship that is a wardship under administration. That's the 14th Amendment citizenship. And we'll get into that here shortly. So, all right. So yeah, the Constitution, they got together, they ratified the Constitution and created a federal judiciary. Now we're going to take a look. I'm going to bookmark this page. We're going to take a look at what Jefferson said about the federal judiciary. He says nothing in the Constitution has given them, the federal judge. I mean, you can look up all these in the individual letters. They're referenced at the end here. I'm just using this source because it's a collection of all the important quotes out of the letters. But you go to archives.founders.gov or founders.archive.gov, rather, sorry. And you just look up Jefferson's letter to Abigail Adams, right? Or his letter to John Wales Epps. And he says, nothing in the Constitution has given the federal judges a right to decide for the executive more than the executive to decide for them. The opinion, which gives to the judges the right to decide what laws are constitutional and what are not, not only for themselves and their own sphere of action, but for the legislature and the executive also in their sphere. So, yeah, he says, where is this one? Hold on. The germ of dissolution of our federal government is in the Constitution of the federal judiciary. An irresponsible body for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today, a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction until all shall be usurped. Let me show you guys the ultimate end of where they're going with this. Let me stop sharing this for a second. Do that. This is obviously my Facebook page. I know maybe many of you might have seen this already. Maybe some of you have not.
Morning, citizens. Your overnight account balances have been updated. Time to start a productive day. Final notice, your account balance is below 500. You need 50 credits by the end of the day to avoid automatic eviction. If you have missed work due to illness, you must provide a doctor's note to reclaim your credits.
Any extra credits? Please.
Tensions are high today, with more people planning to join the Citizens Against Digital Control protest. Remember, the government knows who you are at all times. Resisting is not worth the consequences. All of their newest social credit systems are designed to keep you and your families safe and efficient.
Authorities seized a record balance of an individual's credits, citing excessive hoarding.
Traffic violation detected. 7 miles per hour over the limit. 75 credits have been automatically deducted.
You have to be fucking kidding me.
Yep, you got the flu. Your blood work shows a significant iron deficiency. I recommend incorporating more red meat into your diet.
Dr. Jones, your taxes were not filed and have been automatically deducted with late fees. Your medical license has been revoked.
Oh, hell nah, I filed an extension.
Purchase denied. Monthly red meat allowance exceeded. Try mealworms instead.
Can you guys please let me through?
Attention. Unauthorized political gathering detected. Participants' access to financial services has been suspended. Due to the speeding infraction, your car will be immobilized for 3 days.
Fuck you! Take your surveillance policies and rot in hell!
You've earned 50 bonus credits for reporting your neighbor's hateful misconduct. This content exceeds your current social credit tier. May we suggest citizen responsibility? Sarah, open the door. You have been identified by the authorities. Don't resist. Don't resist. Don't resist.
And see, that right there is perfected neo-feudalism. That's what that is. That's regulation of every aspect of your life. They take away every bit of your autonomy. There's no autonomy anymore. They choose what you watch. They choose what you buy to eat. They choose everything. Everything that you do is controlled, regulated, monitored. That's what these psychopaths want. So when I say that they're nearing the completion of what William the Conqueror started 1,000 years ago, this is what I'm referring to. It is the realization of unum sanctum. It's the one world trust, where everything's under the administration of one singular unelected body, right? Well, at least not elected by the people that it's administering. So that's the danger here, right? And so the very first step was establishing the federal judiciary. And obviously, like I showed you guys, Jefferson spoke out against it. He despised the Constitution. You have to think about this too. That's why a Bill of Rights had to be amended to the Constitution 2 years after it was ratified, because it wasn't included originally. It wasn't intended to have a Bill of Rights because they did not they wanted to take our sovereignty right back. So I contend that the purpose of establishing this country this republic, and giving people, not giving, but allowing people to claim their actual sovereignty, is so that over time they could erode it through the judiciary and give it to the corporations. See, because prior to the creation of this country, there was nowhere in the world where the common man or woman had sovereignty. That was not the case anywhere, ever. Okay. And because of that, here, let me share the screen again real quick. And because of that, that meant everything was always subject to some king, some queen, and all of it was under the Holy Roman Empire. So no matter how wealthy and powerful a merchant oligarch got, like say your Klaus Schwabs and your Yuval Noah Hararis, your Larry Ellisons, all that, no matter how powerful they got, they were still going to be subject to some prince or spiritual authority, like the church. When they created this country, this republic, the common people had the sovereignty, necessarily so, right? We didn't begin using new law. We continued using the common law, but one big difference happened. We were no longer subjects of the crown. That's the biggest difference. The biggest difference, right? And so with no crown above us, no superior authority, we had a allodial title, we had absolute property rights, and the government was instituted to be a utility to facilitate trade, deal with other states, regulate interstate commerce, the federal government, and deal with foreign nations, and to provide a hierarchy in case we needed to mount a defense against an attack. That's it. Never supposed to legislate against your property rights, none of that stuff. Okay, so that's why I think this country was founded. Now, the usurpation of the sovereignty, all of this was only made possible by one other major fraud. I mean, there's been many minor frauds, and I don't have time to go through all of them in one stream. Unless I did it for like 5-6 hours, I might be able to get through a decent amount of them, but I'm not going to do that. However, the other major Jenga piece, or the only major Jenga piece that needs to come out to collapse the entire tower, is the 14th Amendment. That's it. So let's take a look at the ratification of the 14th Amendment a little bit for those of you who may be unfamiliar with what happened there. So what is the 14th Amendment? Well, the 14th Amendment created a federal citizen. Okay, we're going to actually pull up Black's Law Dictionary. I don't actually have it open yet, but I can pull it open real quick. So we're going to take out Black's Law Dictionary, 4th edition. Now you want the earlier editions of any dictionary because now they can't change the definition of things, but what they do is they omit the pertinent parts of the definition. So if we go down to 14th Amendment, right, it's going to be up just a little, down. It's going to be right. Yep, right down here, right here. Okay. Zoom in here for you guys. 14th Amendment. It became part of the Organic Law July 28, 1868, and its importance entitles it to special mention. It creates, or at least recognizes for the first time, a citizenship of the United States as distinct from that of the states. Okay? So it's a whole separate class of citizenship. And like I said, it's a citizenship under wardship, under the guardianship of daddy government, under the doctrine of parens patriae. This was done basically, okay, you don't have common law rights, newly freed slaves, you don't have common law rights. So what we're going to do is we're going to extend our protection over you. Now, this is it's important to understand dependency causes you to come under administration. So I guess I missed that big part of this too. So let me cover that real quick. Dependency causes you to come under administration. Now remember, administration is the regulation and control of people's estates. People who come under administration are infants, paupers, incompetents, right? People who are found to not have free will. It's considered a charitable arrangement. Everything that's done by the administrator has to be for the benefit of the people being administered, right? Or what would you say? Yeah, administer, I guess. So if we look at this, how everything has to be done for the benefit, well, let's actually go to Blackstone again. Go to Blackstone's commentaries, wherever it is. Got a lot of it. There it is. Okay. So we're going to look at dependency. Now, if there's anyone who has no idea who Blackstone is, Blackstone is one of the most respected legal minds in contemporary and even, older than that history. Like, you have so many Supreme Court justices and just legal scholars of all kinds will always quote Blackstone, because Blackstone, he had a beat on it. And it's funny when you read this book, which I've read three out of the 4 books, because this comes in 4 books, 2 volumes. I've read 3 out of 4 of them. And you'll see how he kind of dances around the obvious destruction of property rights that feudalism caused, because obviously he was still living under the king and everything. This is 1765, and it's from England. It's, if you guys get a chance to read it, I definitely recommend reading it. But anyway, so it's going to be on page 45 of this PDF anyway. So it's right here. And this is probably one of the most important aspects of law to understand. So he says, man, considered as a creature, must necessarily be subject to the laws of his creator, for he is entirely a dependent being. And what he's saying is you can't exist without God. You're entirely dependent on God. You have no choice but to be dependent on God because, well, God made everything. So you must subject yourself to his law, which is revealed, which is observed in the law of nature, and is revealed by, like, say, the 10 Commandments, Mosaic precepts, and the other works of the prophets, right? And if you don't realize that law is biblical, then you're not ever going to be able to truly study law. And I know people disagree, especially people who are atheists and try to consider themselves law scholars, but you have to always find the fount of authority. Who gives the right to property? Well, that's something endowed upon you by God, right? And if you don't have a relationship with God, then you believe government is God, which is why all communist nations promote atheism, and the governments are usually satanic. Like over in China right now, you can only get a CCP approved copy of the Bible. That's going to have a lot of things taken out. So probably like 2 Samuel 24, where it says enumeration, such as a social insurance number, is a sin against God. Yeah, they're going to take that out of there because they don't want people to realize, oh, wow, we're actually disobeying God by obeying the government. And then what happens then is if people have a relationship with their creator, a truly spiritual bond with creation, right, then they no longer fear death more than disobeying the creator. And that's very dangerous for the communist governments. They cannot have people who are willing to die for what is right. And that's one of the main reasons. But anyways, let's talk about this. So you're entirely dependent upon God because you can't exist without God. And so because you're dependent upon God, you have to obey his laws. And that's what Blackstone's saying, not my words, Blackstone. It says a being independent of any other has no rule to pursue, but such as he prescribes to himself. And what he means is all beings are dependent upon God. But if you're independent of any other, you have no rules to follow, but whatever you want, so long as you don't hurt anybody or violate their free will, right? He says, but a state of dependence will inevitably oblige the inferior to take the will of him on whom he depends as the rule of his conduct. This is where the settlement laws come from. This is where your birth certificate comes from. Birth certificate is a warehouse receipt, but it also acts as a form of a settlement certificate. Settlement certificates were created in the 1600s by, I think, Queen, I want to say Elizabeth. And they were issued to paupers to give them a right to reside and work in a certain, I forget, parish or whatever, right? And they could not go outside of where that certificate said they should be. And then on top of that, they were administered by the church. The church controlled the poor over there. Well, still do. That's why judges are ruled by judicial canons. But anyway, so they were administered by the church. And what would happen is the merchant oligarchs would set up workhouses, and then the church would pimp the poor people out to the merchants' workhouses for cheap. And it's all profit for the church because they're, administering these people. And so because you're a pauper, you're found not to have free will. You come under administration for your own benefit and protection, right? That's how they say it. And then you're regulated. And that's so. What does this have to do with now? Well, the 14th Amendment is exactly that. The 14th Amendment causes you to come under the wardship of the federal corporation for protection and benefits. In exchange, you are under administration. And this entire republic is one big corporate workhouse. It's one big tax plantation. That's all it is. Right? So, well, we got some drama going. All right, I'll address that at the end of the stream. I'm not going to, like, hey, you got a wrench, Pat, so use it if you need to. Anyway, yeah, I don't know who you're arguing with unless it's another, somebody that's a friend of the channel. But anyway, so it's one big corporate workhouse. All right. And not having access to lawful money makes you a pauper. And the fact that the money you do have access to is secured by the mortgage of your own estate even further adds to the fact that you have no property rights. Okay. But this was only done by the 14th Amendment. Now, the 14th Amendment citizen is a creature of the federal corporation. This is how it works. The people created the states created the federal corporation. The federal corporation made its own creature called the 14th Amendment citizen. And the creator can never be subject to the created. And that's why they rule over us as if they are daddy government right now. That's exactly why, because they are basically daddy government to the 14th Amendment citizen. Here's the catch, though. 14th Amendment citizenship was never actually lawfully ratified in the first place. In this case right here, nope, not Chisholm v. Georgia, sorry. I think it's this one. Diet v. Turner, right? Talks about it. The entire, goes into detail about how basically what happened was they needed 3/4 majority. That's what Article 5 says to ratify an amendment. They needed 3/4 majority, and they didn't get that. So what they did was they found these different ways to exclude certain states from the ratification process, and then other states, they just went down and absolutely replaced the government at gunpoint with a proxy government that would vote yes. And then even though it still wasn't ratified, Congress in an act declared it to be ratified and part of the Constitution. And that's all delineated right here. So it wasn't even ratified, lawfully ratified. There was another case I was looking at just before I started the stream that one of the jurists sent me. And it says right here, I cannot believe, and let me see, what's the title of this case again? State v. Phillips from 1975. It's a Utah Supreme Court case, okay? And it says, the 14th Amendment is a part of the Constitution of the United States. While the same assertion has been made by the United States Supreme Court, that court has never held that the amendment was legally adopted. They've never looked at the process. They've never said, was this actually lawfully ratified? Because it was not. Okay, and we're going to get into that whole story too. It was not lawfully ratified. And if they did look at it, like this court says right here, he says, I cannot believe that any court in full possession of its faculties could honestly hold that the amendment was properly approved and adopted. But they pushed it through at gunpoint because none of this system would be possible without it. No part of the system would be possible without it. The 14th Amendment is the key. It is the linchpin. It is the Jenga piece. You take it out, the whole tower collapses. And I'm showing you guys why we have the right to take this piece out. It was never lawfully ratified in the first place. And secondly, it's voluntary. So even if it was, which it was not, lawfully ratified, it is freaking voluntary, right? So you've got, I've got several cases that delineate the voluntary nature of this is Cruden v. Neal. We might get into that's a good one if I pull full circle to that. Where the hell did I have that open at? You know what? I'll just open it up somewhere else. We will do Santa Clara County, Interim Award. Oh, yeah. And then we got to talk about the 13th Amendment as well. So this is Cross v. Board of Supervisors of Elections of Baltimore City. Now look how they black out. Look at this. I wanted to show you guys. This is Harvard Case Law Access Project. They black this out like it is a top secret CIA document. Okay, now why do they do that? Well, let's look at this same document from another website called CaseMine. In CaseMine, an AI legal resource, they actually don't block that out. I don't know if that's an error or what, but it's right here. State citizenship, okay? It says a person need not be a United States citizen in order to be a citizen of his state. Look how important it is for them to have you never learn this. Blacked it out like we wouldn't find it somewhere else. Right. So it is a person need not be a United States citizen in order to be a citizen of his state. It's right here. OK, then we've got obviously the tried and true Indiana Supreme Court. This is going to be McDonnell v. State. And basically, you go down this guy. He tried to challenge the ruling of a jury because he said one of the members wasn't a United States citizen, says that he's an alien. And they said, well, the evidence of bushing, that's the juror's name, on his voir dire, which is a competency hearing for the juror, showed that although he was not a citizen of the United States, he was a citizen and voter of the state. Under Section 2 of Article 2 of our state constitution, one may be a citizen of a state and yet not a citizen of the United States. And this is the case in every state. It doesn't matter that it was Indiana. First of all, Article 4, Section 1 demands that all states give full faith and credit to the judicial decisions of every other state. So it doesn't matter where you find a court case. If you use that right there makes all court cases of all states apply to every state. Doesn't matter. Okay. And secondly, the equal footing doctrine. All states enter in on equal footing. That's why, like with the allodial title being in the Wisconsin Constitution, that has to necessarily be the case in every state. Otherwise, Wisconsin could have never put that in their constitution. But we also have the report from the commissioner of the General Land Office. And that does disclose that. So it's voluntary. Okay, citizenship's voluntary. United States citizenship's voluntary. And really citizenship in general, right? So let's take a look at US v. Anthony I have somewhere. This is a good one, but no, we want US v. Anthony. Here we go. US v. Anthony. So this is from 1873. And it was basically just after the 14th Amendment was ratified in 1868. And this chick tried to say, well, now I can go vote, basically, right? So, and enfranchisement, the right to vote originally, and listen, first of all, voting, being registered to vote as a United States citizen is one of the contractual nexuses. And the whole trying to get everybody the right to vote, you become a registered voter, you're part of that corporation, right? So now you can vote on the board that runs or the executive offices that run the corporation. But secondly, you're supposed to be a landowner and have a vested interest in the state in order to be a voter of the state, and you had to be a citizen. So it had nothing to do with color and stuff like that. It was literally your status. Like, do you have a vested interest in the state? But that's not what we're talking about. So anyways, it tells you right here, the 14th Amendment defines and declares who shall be citizens of the United States and protects only such rights as are rights belonging to persons as citizens of the United States and not rights belonging to persons as citizens of a state. Right there, black and white. Okay. Then we've got Maxwell v. Dow. That tells you as a United States citizen do not have the protection of the Bill of Rights. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. So that's your right to a trial by jury. That's your right to know the nature and cause of the charges against you and face your accuser. That's your freedom of speech, your right to bear arms. And that's how they're able to actually legislate against the Second Amendment. First, they change it. There are no actual laws against bearing arms. There's laws against bearing firearms, which is a commercial term. Okay. Now, the creation of the judiciary, the federal judiciary, is how they've done this. And that's why, so it's up to the federal judiciary under this current system to take a look at the ratification process of the original 14th Amendment, but they're all in cahoots because they're all bar members. They're all esquires. Right. And so they're acting in concert to not undermine the rulings and decisions of any other bar member that's furthering this plan to create a neo-feudal totalitarian police state under the yoke of an unelected tribunal of oligarchs. So let's look at some of the protections that the founders put in to try to stop that. There was an original 13th Amendment. Okay, so first of all, we'll start with this. All bar members are esquires. Okay, a lot of them actually just put ESQ after their name. They actually put their title after their name. Now, it's a shield bearer or armor bearer, scutifier, and attendant on a knight. Okay, but in modern times, a title of dignity next in degree below a knight. So it's above a gentleman, below a knight. All right, and it's given to counselors at law, well, attorneys. Okay, so they're all esquires. Now, what's funny about this, you've seen it said a shield bearer and attendant to a knight. Well, the bar associations were created by the Inns of Court. Now, you probably have no idea what the Inns of Court are, so I'll explain to you real quick. What's going on in the chat, Grammy? Hold on. Posted in good faith. Okay, well, if you guys are fighting in the chat, let's try to try to not do that because I've still got a lot of information to get through, and I am trying to keep an eye on the chat here and there, but I'm trying to keep the flow of this going. So, yeah. So anyways, esquires, that's what attorneys are, esquires. All right. Shield bearers, scutafire to a knight. Now they're created by the Inns of Court. The Inns of Court are an unincorporated secret society that was created in London. They're unincorporated, so they can't be sued or taken to court or anything like that. But they are 100% secret societies, and they're composed of 4 inns. Those inns are the Inner Temple, the Middle Temple, Lincoln's Inn, and Gray's Inn. Now, it's rumored that the Middle Temple is the one that controls us. Chief Justice John Roberts is a member of the Middle Temple. Okay. And they're under the crown, but not the crown that you think they are under, right? They're under the empire, and they are basically the civil officers carrying out. See, the banks could never, like, this couldn't be done by the banking systems alone. It takes the attorneys, the bar members working in tandem with the banks to erect the system. See, the bar members have to legislate. First of all, how does the bank get established? They have to legislate the Federal Reserve Act. And then the security scheme, once they moved us to fiat currency, how is that going to operate? How is the trust indenture going to operate? Well, the bar does all that. They work directly with the bank, and both of them are under the control of the Holy Roman Empire. Now, the Inns of Court are in the Templar building, the old Templar church in Rome. The Templar church are... well, at least the Inner Temple and the Middle Temple are in the old Templar church. Okay. And that's important to understand because check this out. What is a Templar? Let's take a look at that. Templar, number 1 answer, a student of the law. Okay. So Templars, essentially in the Inns of Court, are what I take from this is to be the Templars, and they're knights. And so you look at, again, we'll go back to Esquire, and what are the attorneys? They're esquires. And they're shield bearers or armor bearers, scutafire, and attendant on a knight. So they're the minions of the ones carrying this out from the Sovereign District of London. That's what's going on here. So we had an original 13th Amendment. We had an original 13th Amendment to protect us against this. And it wasn't the abolition of slavery. I'm going to show you guys some very, very cool stuff, though. I know many of you have seen it in the reel that I made the other day. Well, let's see. We're looking for this. Now, this is a very good compilation of exactly why the original 13th Amendment was ratified. And I'm going to show you that it was ratified, but let's start with what is the 13th Amendment. It's right here. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind, whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. So, esquires would immediately be barred from citizenship because that's a title of nobility, would be immediately barred from citizenship and could not hold office. So if this was reinstated, it would literally eliminate all the judges. All the Supreme Court would be gone. All the judge, everybody in the legal in the judicial branch of state and federal government would be gone. Because that's how deeply entrenched they are and how they've hijacked our entire system. And the framers of this amendment weren't idiots. They did this on purpose. They knew that the esquires, the same people that wrought judicial havoc over in England, were going to try to do the same thing here through the federal judiciary. In the same way that Jefferson and George Mason and all them warned against the federal judiciary and the Constitution, there were people that knew how to set this up, right, to make sure that they weren't able to do that. So this was on the books. Now I'm going to tell you guys the story of how this happened, and then I'm going to show you evidence. So in 1810, as it says here, Senator Reed proposed the Titles of Nobility Amendment, History of Congress, Proceeding of the Senate, blah, 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 right? So by 1812, which I have this is a cool document I have here, American State Papers from 1818, and it tells you that by 1812, it needed 13 states to be ratified, and it had 12. Only 2 states had rejected it by then, right? And it was New York, obviously, because look, a commie runs New York City now, so not surprising, and Rhode Island. But these 12 states had voted to ratify it. Now, the ones still up for grabs were South Carolina, Virginia, and Connecticut. If I remember correctly, it's Connecticut. Okay, and they hadn't voted one way or another yet. And so, in California, I think, actually. No, not California. What am I talking about? They weren't even, but yeah, it was Connecticut. So, anyways, then what happened in 1812? The War of 1812, right? And now everybody knows that was a banker war because in 1791, the first Bank of the United States was established and given a 20-year charter. Well, that 20-year charter was up in 1811. And when the bank went before Congress to say, hey, are you going to renew our charter? Congress said, nah, we got it from here. We're good. Thank you. And obviously that pissed the Rothschilds off. And so if you actually look into the War of 1812, its beginning is nebulous and its ending is nebulous. They say it was a draw. Really what happened was they agreed to establish the central bank. But I also think that war had a lot to do with this amendment because while they were over here, while the English were over here and the Canadians attacked us too from the north, they started burning courthouses and record buildings and all that stuff. They were trying to get rid of this amendment. Now this is proven, right? So by 1818, when this was written, this amendment, the 13th Amendment, is still just sitting there like, are we going to ban titles of nobility or not? We still haven't gotten an answer. We had this whole war going on. 1818, they have no idea. What are we going to do? We need one more state. Okay. Well, then in 1819, Virginia voted to republish its revised codes. And now, while there's no record of Virginia actually ratifying the amendment because all the records were burned and stuff, right? There is this book, this law book, which is prima facie evidence at law that they did ratify it because look at this, Article 13. This is the revised laws of, or revised code of Virginia, 1819. Here's Article 13. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility, et cetera, et cetera. So this, yes, they had 13 states. It was ratified. The fact that it disappeared, they never give you a good reason for it after the Civil War. But this right before the Civil War, so it was on many law books and gradually started disappearing state by state till we got to the Civil War. And right here, this is 1867 Colorado Revised Statutes. Now, look what's interesting about this. And I got this right off of, I believe it was Google Books, something like that. Anyway, this is the revised statutes of 1867, Colorado. And look at this, Article 13. If any citizen of the United States shall accept. So all the way up to 1867, this was on the books. Now, here's what's even more curious. This revised statute book was after the 13th Amendment, the one that is the 13th Amendment, was ratified. So the 13th Amendment appears as the 14th Amendment, neither slavery nor involuntary servitude except as punishment for crime, et cetera, et cetera. It's listed as the 14th Amendment. So it absolutely was ratified. Right? So we came across, let's see, this right here. This is from the state of Montana just from 2 years ago, 2023. A bill for an act entitled an act recognizing the original 13th Amendment to the United States Constitution, allowing the retention of offices of Bar Association members until the original 13th Amendment becomes part of the United States Constitution, providing an appropriation and providing an effective date. So they're going to phase the bar out. That's what Montana wanted to do 2 years ago. I wonder if the people that introduced this are even still alive. I haven't looked, but probably not, or they're at least not in office anymore. So it says, whereas in 1810, an amendment to the United States Constitution prohibiting titles of nobility was introduced by the United States Senator Reed, passed both houses of Congress, and was sent to the states for ratification. Right? And whereas this amendment, now known as the original 13th Amendment, states, if any citizen of the United States shall accept, claim, receive, or retain any title. Yeah, we know what it says. We read it like twice or three times now. So it says 13 states were necessary to ratify the proposed amendment to make it part of the state's constitution, or United States Constitution. It says, whereas 12 states ratified the 13th Amendment between 1810 and 1812, shortly before the outbreak of the War of 1812. This is actual legislation. This is House Bill 933. You can look it up, Montana House Bill 933. You can look it up right now. This is actually, it's proposed, right? So it says, during which time, the War of 1812, during this time of the War of 1812, right? During which time many records were destroyed in the tumult of war. Well, isn't that convenient? It makes you wonder if that's the reason that war happened, right? One of them anyway. The bank was definitely the other reason, but It says, whereas there exists no record of ratification or rejection by the state of Virginia regarding the original 13th Amendment. However, Virginia passed legislation to republish its civil code and the United States Constitution and its amendments on March 12, 1819, which was this that I showed you. It's right here. This is from Hathi Trust. It's a revised statute, and there it is, passed March 12, 1819, over here in the corner, Volume 1. Here's the 13th Amendment, right? There it is. So, anyway, Virginia's republication of the laws included the original 13th Amendment to the United States Constitution, thereby announcing its ratification of the amendment. So no bar pirate, none of these idiot politicians can say, oh, it wasn't actually ratified. Bro, it was on the books till 1867. And the Abolition of Slavery Amendment was listed as the 14th in Colorado. So you can't tell me that it wasn't actually ratified. Of course it was. And you know what? If the people, and here's the thing, this is the problem, trying to write bills like this and trying to, oh, we're going to elect him out of office next time if he doesn't do, dude, they're never going to fix themselves. The government is never going to fix government. The same thing that happened in 1776, we need to fix the government, right? We don't know, hey, please recognize that this amendment was unlawfully taken out. No, we just need to get the people to recognize that it was unlawfully taken out, and it has subsequently led to the usurpation of our entire nation by a bunch of bar pirates, bunch of esquires, right, that are just moving us headlong into a digital prison. They're not going to recognize this, but I'm showing you conclusive evidence that it was ratified. Conclusive evidence that it was ratified and that it stands and was never lawfully repealed or anything. It stands. So you got the 13th Amendment, the 14th Amendment being unlawful, the 13th Amendment being, unlawfully taken out, the 14th Amendment being unlawfully ratified. And those two things are the linchpin to the entire system, primarily the 14th Amendment, but this doesn't hurt either. Get rid of the esquires, right? It's literally going to take the people to stand up and say, no, dude, we're not, we don't care what you legislate. We don't care what you're writing on a piece of paper. We're not going to vote. What we're going to do is tell you, fix this or 1776. During World War II, there was I believe it was an admiral, a Japanese admiral, refused to attack the mainland of the United States. It might have been a general, something like that. But anyway, he was high officer. He refused to attack the mainland of the United States. And when he was asked why, he said, because behind every blade of grass will be an American with a gun. That's why. That's why. What are we doing? What are we doing right now? Why are we just sitting here passively accepting this shit that's going on in Minnesota? Are you kidding me? Why? And they're just like, oh, well, the government's going to get them. The attorney general, dude, they're a bunch of crooks. Both sides are crooks. It's a big mafia. What are you talking about? They're not going to get them. What you need to do is sack up and get them out. That's what needs to happen. That's what needs to happen. There's no question about it. So, anyway, are you guys still fighting in the chat? Come on now. Yeah, they are all crooks, Raj. So the original 13th Amendment, okay? And then it was this, like after the 14th Amendment was this unlawfully ratified. Now there's a story about let me tell you that story. This is a good story, right? Let's look up some quotes too. We'll have to go to Yandex for that. We're going to go boom. And a lot of people don't even realize what the Civil War was actually about and who was behind it, right? But let's say Lincoln's quote about the Jesuits. And it isn't one group over another, right? It's all of them. It's all of them. They're all just different factions of the same ancient Babylonian money magic group that worships the devil, dude. That's who it is, okay? Doesn't matter whether they masquerade as a pope or masquerade as a Jewish guy or masquerade as whatever, right? Because they're not that. They're this ancient Babylonian, they're the bloodline of the serpent, basically, but I'm not going to get too much into that because I know some people get triggered by it. But let's check out some of this stuff right here, right? So this was all these quotes come from 50 Years in the Church of Rome by Charles Chiniquy, who Lincoln, when he was an attorney, before he was a politician, he got this guy off of a rape allegation, whatever you want to say on YouTube, right? But anyway, it was an allegation that he did some untoward stuff to a woman, and it was perpetrated by these people, right? And Lincoln got him off, and then Chiniquy was like, I feel bad for you, Mr. Lincoln. He said, I seen like 14 Jesuits in that courtroom with the look of death on their faces, So they like had it out for Lincoln. Now, Lincoln wasn't a hero. He was a tyrant who destroyed our original Confederate Republic, established a corporate union. But I don't think he was a willing participant. As much as I've studied into it, I think he was an idealistic idiot who thought he was doing the right thing and did irreparable damage. Because after the war, one of the things that got him killed was he restored the southern states to their pre-war status, which is how they were able to ratify the slavery amendment, abolishing slavery. And then because the states rejected the 14th Amendment, they then said, they're an open rebellion and all that, and removed their legislatures, ignoring the fact that they were absolutely allowed to ratify the abolition of slavery amendment. But anyways, that's one that did them in, because they needed the Reconstruction Acts and the military occupation of the southern states, which just spread to all the states, by the way. That's where we've been under a state of perpetual martial law since the Civil War. It has not gone anywhere. And that's how they set up the neo-feudalistic system, is because that's a military style of government. But anyways, says this war would have never been possible without the sinister influence of the Jesuits. We owe it to popery that we now see our land reddened with the blood of her noblest sons. Though there were great differences of opinion between the South and the North on the question of slavery, neither Jeff Davis nor any one of the leading men of the Confederacy would have dared to attack the North had not they relied on the promises of the Jesuits, that under the mask of democracy, the money and the arms of the Roman Catholic, even the arms of France, were at their disposal if they would attack us. I pity the priests and the bishops and the monks of Rome in the United States when the people realize that they are in great part responsible for the tears and the blood in this war. Right? So that's pretty damning stuff. That's as much as I'm going to read about that, but I'll link this in the chat real quick. You guys can read it at your leisure. But anyways, so we know Lincoln was assassinated, but very few people know that the plot to assassinate Lincoln was actually a plot to assassinate Lincoln, William Seward, the Secretary of State, the Vice President Andrew Johnson, and Ulysses S. Grant. Now, this was hatched by the Surratts, who were Roman Catholics. He had Mary Surratt and John Surratt, and then obviously John Wilkes Booth and one other guy. And so here's how it played out. When they went to assassinate these people, you had Ulysses S. Grant left town for the day to visit a sick friend, and his assassin missed him. Andrew Johnson's assassin chickened out. William Seward's assassin came to his house, and when he knocked on the door, the assassin stabbed him a bunch of times, and he almost died. So you don't ever learn about that in school, do you? That the Secretary of State was also attacked as part of the same plot. And then that's also why the Secretary of State, when it came for just pushing through the ratification of the 14th Amendment, he did what he was told, because he just almost got killed. And then obviously we know Lincoln was killed by Booth in Ford Theater. So now, how do we know this is true? Well, because it's historical fact that John Surratt, the other ones were caught, the John Surratt escaped into Canada, was hidden out in a parish, a monastery, right? And then smuggled over to Rome, where he was put in the Pope's guard to hide him until somebody recognized him. And this is a historical fact, because somebody recognized him, and they arrested him and brought him back over here to the United States. And then he got let go by a stacked jury. It was a hung jury. They let him go. This is the guy who hatched a plot to kill the president of the United States, and they let him go. Okay. Now, we ceased diplomatic relations with the Holy See from that time all the way till Ronald Reagan. These are facts you never learn, right? So I'm not trying to dog the church. I do think the church is the original church, and I know many people disagree with that, but just like every other institution, its government is corrupted, right? Power corrupts. Absolute power corrupts absolutely. So not trying to offend any Catholics or anybody like that, but you can't talk about history without bringing up these facts, right? and bringing up the Treaty of Verona and the fact that the monarchs of Europe and the Holy See are entirely opposed to popular sovereignty because they believe in divine right to rule. And they think that popular sovereignty is a threat to their hegemony, right? So we've got the secret Treaty of Verona right here. Let's see if I can pull it up real quick. Treaty of Verona. No, you're not going to pop up. Is it this? Yeah, it's this one. Whoops, wrong window. My bad. Hold on. Boom. So this is, what page is it on? I want to say it's on page like 50 something. 55. It's going to blow your mind though. This is in congressional record. So where are you? Nope, not that one. Well, I didn't think to pull it up this time, and it's actually from it was entered into 1918, I want to say, or 1917, into the congressional record. So let's see if I can find it real quick. Because I know I have it in my PDF or in my files, but it's not popping up for some reason. My stupid computer does that occasionally. So it like won't give me what I want. So yeah, it's got to be in this document. Anyways, I'll tell you what it is. So in the monarchs of Europe got together with under the Pope for a treaty in 1823, I believe 1822 or 1823. And they discussed how popular sovereignty over here in the United States was a dangerous idea to their rule, and how they had to agree to enter into an alliance called the Holy Roman Alliance to end popular sovereignty anywhere it may rise up in Europe and the rest of the world. And this is actually in a treaty, and it was supposed to be secret, but now it's on congressional record. We have it straight from congress.gov. You can look it up. It was in I can give you the details. I just apparently can't find it right this second, but I do have it, and I've shown it before. And it is on congressional record, and you can look it up yourself if you don't believe me. But James Monroe caught wind of this treaty, and that's what the Monroe Doctrine is all about, where it basically says, we know what you guys are planning over there. We know what you're doing, okay? And if you come and interfere on this side of the world in either of the Americas, we're going to take it as an act of war, and it's on. And that's literally what the Monroe Doctrine is all about. So, and that's a direct response. So it's not like this is a surprise. If you guys are shocked that we're being usurped by Roman civil law, it was an inevitability as soon as the people started forgetting the law. You stopped learning the law. You forgot who you were. You forgot that you're the sovereignty. You forgot that you are the power in this country, right? And what it means to be sovereign. What does it mean to be sovereign? Absolute property rights. All law revolves around property. Okay. And all rights are derived from property, and your relationship with your property determines your status. And your status dictates whether you're a freeman, a subject, or a slave. And right now, everyone's slaves. So I didn't even show you guys. Here's the absolute proof. And I wonder if I have Senate Report 93. Senate Report. If not, I can look it up. Yeah, Senate Report. We'll do that real quick. Senate Report. There it is. It's 93-549. So Senate Report 93-549. 93-549. My files are, we'll just put it up here and it'll come up and we'll look at the PDF. If you guys have never seen this, this is smoking gun evidence of what's going on. As if I haven't given you guys a bunch of that already, but do that. So this is an actual Senate report that was issued in 1973. And it says, since March 9th, 1933, the United States has been in a state of declared national emergency. In fact, there are now in effect 4 presidentially proclaimed states of national emergency. Now, what this document actually forgets to tell you is that we've been in a national emergency since the Civil War. They never lifted the Lieber Code, which was the martial law imposed at that time. And the entirety of the republic has been under the military command of the United States Corporation ever since. Okay. That's why the president, the executive commander in chief of the military, can just, with a stroke of a pen, write things that affect your life. So it says these proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate to the president extraordinary powers ordinarily exercised by Congress. And now it says since March 9th, 1933. Well, what happened in March 9th, 1933? Let's take a look real quick because I have that congressional record also. And this one is easy to find in my files. Whoops. It's a GPO, Government Printing Office. I believe it is this one. Nope, those are the impeachment charges, but we can take a look at that too. Those are impeachment charges against the Federal Reserve. So, but this one right here is one we want. So this is House Congressional Record, March 9th, 1933. See, it says 1933 there. Go up here and show you where it says March 9th, 1933. We'll zoom back in so you can see it real well. And it says the money will be worth 100 cents on the dollar because it's backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. They mortgage your estate. Now, they could only ever do that to a 14th Amendment citizen. They could never do that to the people of the states because Congress doesn't have jurisdiction over the people of the states. Hell, the state doesn't even have jurisdiction over the people of the states. The only entity that can gain jurisdiction over one of the people is another one of the people. And that's with a verified complaint, an affidavit that they've been injured, right? Signed and sworn in front of a magistrate with witnesses. And then you come under the state or come under, well, the powers of it anyway. But other than that, no. And they damn sure couldn't do it from the federal government. They could only do it to 14th Amendment citizens. That's why it was so important for them to ratify the 14th Amendment, why they did it at gunpoint. So they mortgaged the estates of the people. Okay, let's continue. That's what happened in March 9th, 1933. Right. So under the powers delegated by these statutes, the president may seize property, organize and control means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation, communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. So go down and it says basically the way that it starts out. Says a majority of the people of the United States have lived all of their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution, and now it's not been 40, this is 73, right? So you got to add another, 52 years to that. So it's actually now 92 years we've been living under this tyranny. And it all, if you remove the 14th Amendment, it all goes away. It all goes away. That's how you do it. And you have the right to, because again, United States citizenship is voluntary. And this is, again, Senate Report 93-549. I'll link it real quick. Copy, link it in the chat here. All right. Now, the other thing was the establishment of a central bank. They could never do this without the establishment of a central bank. The whole name of the game was how are they going to overcome the sovereignty of the people? So they had to reduce your status via the 14th Amendment, and then they had to indenture you to a third-party financier, which is the Federal Reserve. Well, check this out. This is from May 23rd, 1933, and these are impeachment charges issued by Louis T. McFadden, a representative. Forget which state. But anyways, he says, Mr. Speaker, I rise to the question of constitutional privilege, right here, on my own responsibility as a member of the House of Representatives. I impeach Eugene Meyer, former member of the Federal Reserve Board, and he goes on to list all these Federal Reserve Board members, former and present treasurers and secretaries of the Treasury, and on and on and on, goes all the way down. And he says he charges them for where's that here? It says, I charge them jointly and severally with violations of the Constitution and the laws of the United States, whereas I charge them with having taken funds from the United States Treasury, which were not apportioned by the Congress of the United States. And I charge them with having unlawfully taken over $80 billion in 1933. And this isn't precious metal. This isn't fiat paper. 80 billion they stole from us, right? He goes on to say they did it in the year 1928, and with similar thefts committed in 1929, 30, 31, 32. Whereas I charge them jointly and severally for having unlawfully created claims against the United States Treasury by unlawfully placing United States government credit in specific amounts to the credit of foreign governments and foreign central banks have issued, being the Bank of England. They hold a lot of our debt. And, well, not our debt, their debt. That's the whole point. That's the whole point of getting rid of the 14th Amendment. It's their problem. It's not our problem. You do that and they have no more federal chattel to leech off of. So, but here's the funny thing about this. And he goes on to list how they converted the people and their estates into collateral and so on and so forth. The whole thing's really good. And you just look it up on congress.gov. You go to March 23rd or May 23rd. 1933 House congressional record. Use the search filters, pull up this document. I can't share the PDF because it's a PDF and it won't, click it, it's not going to do anything. But you can see I got it from congress.gov because it's GPO, Government Printing Office, right in the file, right? So, and these charges are still open. So what happened after he levied these charges is they kicked them over to a judiciary committee, right? Or some committee. And then it just sat there. And he kept raising the question over and over again, like, hey, this is what's going on. This is what the Federal Reserve's doing. They called him anti-Semitic. They called him a bunch of stuff, right? It was before the term conspiracy theorist existed. But if that did exist, they would have done it. They tried to kill him twice. They poisoned him, tried to poison him. He lived through that. Then they shot at him in his house and he lived through that. And then a third time in 1936, he went to some political banquet and then fell ill immediately after. And a lot of people say he was probably poisoned. I mean, it's not conclusive. And you know why? Because no autopsy was done. Why would they do an autopsy, right? Same old MO, same exact playbook over and over and over again. So yeah, that's a situation there. We have this as well. This avenue is the impeachment charges that we can bring up. Hey, what about those impeachment charges that are just still sitting there open, never been answered for how long now, right? Like 90 years, 92 years? It's 1933, 92, almost 93 years, just sitting there, unanswered. And he calls them out on exactly what they did, So having taken, whereas I charge them jointly and severally with having purchased United States government securities with United States government credit, unlawfully taken with having sold the said United States government securities back to the people of the United States for gold or gold values, and with having again purchased government securities, right? So on and so forth. And they can wash, rinse, repeat, doing the same thing over and over again. Right here for unlawfully charging them with having unlawfully exported gold reserves belonging to the national bank depositors, gold belonging to the general public of the United States to foreign countries, and with having converted the said gold into foreign currencies, with having used it for the benefit of foreigners and for speculative purposes abroad. So you want to know why this whole system, so you've got this thing with the governor of Minnesota, right? We'll take a look at that, and then I can explain to you exactly how this happened. So we'll do a little search, and we're just going to say Somali, Minnesota, right? I'll pop up here where he's going in. Yeah, we'll just take a look at this one. Let me reshare the screen. See, because everybody's all surprised, but this is what the government's been doing since this system's been established. I'm going to show you how, but let's just watch this real quick.
My name's Nick Shirley.
You don't have any permission to record me, period.
Can we talk outside?
You don't have permission to record.
She doesn't have permission to record me.
You cannot stop people on the street and question them.
We can ask.
You don't have any permission.
Where are the children?
I'll sue you. You don't have any permission. We have nothing to do with this.
Okay. Then are there
so leave. Please leave.
Are there children here?
Please leave.
So you guys get the idea. These guys are opening up daycares. They're opening up learning centers and all this stuff everywhere, right? Taking government appropriated funds that are supposed to be for welfare and funneling them through the illegal Somali immigrants in Minnesota. It's happening in Ohio. It's happening in, forget where Wisconsin, Green Bay. So it's happening in a bunch of places across the United States, and they're using these illegal immigrants to funnel the money through, which is not money, it's just credit, actually, paper credit, through them back into their own pockets. Well, this is what they've been doing the whole time. So let's explain how this will be the final piece of the entire puzzle for you guys of how this works. Okay, so all law regards property. Your relationship to your property determines your status. Okay, and if somebody else can tell you how to use your property and dispose of your property, then you're not free. Just that simple. Okay, so 1930, first, the 14th Amendment happens. By virtue of what the 14th Amendment is, you come under the administration and guardianship of the federal corporation, just like that, because they're supposed to protect you and give you privileges and immunities. So they have to have an interest in you and be able to tell you what to do to make sure that they're protecting you, right? So you come under the administration of Congress. Congress can now legislate your rights, civil rights. They're equitable rights, they're not lawful rights, and they can be changed and taken away. Then slowly but surely, they bring everyone under the umbrella of this federal citizenship. Like, so I've got this Van Valkenburg v. Brown. This is all going to make sense by the time I get done explaining it to you. This is Executive Scrutiny v. Neal. I'll just put it in the, I'll just do this. Van Valkenburg v. Brown. Van, there it is. Case Law Access Project. Boom. It's a very hard case to find, actually, and you'll see why, especially when we look at the scanned PDF. It starts off right away. No white person born within the limits of the United States and subject to their jurisdiction or born without those limits, which means without the territorial limits outside of the federal zone, okay, and subsequently naturalized under their laws, owes his status of citizenship to the recent amendments to the federal Constitution. So the purpose of the 14th Amendment to the Constitution was to confer the status of citizenship upon a numerous class of persons domiciled within the limits of the United States, who could not be brought within the operation of the naturalization laws because, though native born, and whose birth, though native, had at the same time left them without the status of citizenship. Such persons were not white persons, but in the main were of African blood. Now, before you guys get pissed about that, here's the thing. Even Andrew Johnson, when he vetoed the Civil Rights Act, which originally created the federal citizenship, he said this is unnecessary. He said because the avenues of freedom have just opened up for the African Americans, and in time, they will be able to learn the institutions and exercise their unalienable common law rights. Contrary to what they try to teach you in school, because people are ignorant of the law, they have no idea how it works, they were not going to be indentured because they were black. They were going to be indentured because they were dependent and servile. And that's the whole, and it's not their fault. They were kept in a state of dependency and servility as slaves for generations, so that when they became free, they had no idea how to survive on their own, which is not their fault, right? And I'm not going to say all of them, but a lot of them, enough of them in general, that the United States was able to, slide in there and establish this 14th Amendment. And so the 14th Amendment is a trust office placing these people as wards under administration, under the guardianship of the United States Corporation. And what this shows you is that under the 14th Amendment, it established state supremacy. But the point of this is it was made so they had to slowly bring in everyone else under the 14th Amendment, which they did over time. People started naturalizing, becoming United States citizens for whatever reason. A big way that they did this was by bringing in immigrants. Immigrants are always what they use, because generally when immigrants come over here, if they're not well-established, wealthy immigrants, which most of the time they're not, they're immediately dependent on the government, and they do what the government tells them to do. And that, like Somalia, right? Okay, so now that we've established that, they could only mortgage the estates of 14th Amendment citizens because they had guardianship over them, as we've been discussing, and as we've seen, not here, but here, where it says, represent a mortgage on all the homes and all the property of other people in the nation. I've also got another PDF called The Rise and Rise of the Administrative State. It's right here. And he goes into it as well. And this is a law review. This is a Boston University School of Law, right? And it's a it's a law review by a law student. And it says the post-New Deal administrative state is unconstitutional, and its validation by the legal system amounts to nothing less than a bloodless constitutional revolution. The original New Dealers were aware, at least some degree, that their vision of the national government's proper role and structure could not be squared with the written Constitution. The administrative process, James Landis's classic exposition of the New Deal model of administration, fairly drips with contempt for the idea of a limited national government subject to formal tripartite separation of powers, meaning 3 branches. Okay. And says, faced with the choice between the administrative state and the Constitution, the architects of our modern government chose the administrative state, and their choice is stuck. And this was done. So what is administering? It's basically holding an incompetent in trust and regulating his use of property and his behavior and everything else. It's what administration is. Okay. And I've explained that ad nauseum, but I can't hammer that home enough. Right now, here's the catch with administration. It has to be, everything that the administrators do have to be for the benefit of those under their administration, like taking care of wards. That's exactly what it is. So you'll notice this language every time Congress appropriates money. Okay, check this out. We're going to go 42 right here. How many of you are fans of the space program? All right. I'm not particularly, but check out the language they have. So first of all, the space program, see all the money they're appropriating for all their administrative agencies and all their little black budget projects. It all has to be under the guise of being for the benefit of the United States citizens, the pauper infants under the administration, right? All has to be under that guise. And so when the language they use is very revealing. You see this, first of all, it has to be under public health and welfare. Okay. Welfare. That's exactly how you come under administration. Says National Space Program. Now, check this out. Says the Congress declares that the general welfare and security of the United States require. Go down to the next section. The Congress declares that the general welfare, they have to keep saying welfare because they're borrowing against your estate. They're borrowing against your property rights. So they have to justify it by saying it's for your benefit. And I don't know what benefit the space program has ever supplied other than a bunch of BS, which is not beneficial, right? So, but that's how they do it. Look, we'll go down a few more. Here's the next issue. The Congress declares the general welfare of the United States. So that brings me back to the Somalis, all right? This has been going on the entire time. Now they're just using illegal immigrants to do it. So what they do is they appropriate money and be like, okay, well, we've got these poor disenfranchised people over here, right? Even back like ever since the New Deal, just like that guy says in that law review, ever since the New Deal, it's the name of the game has been how do we funnel public credit into private pockets? And so what they do is they go, okay, we need to establish a new housing commission. We need to provide free housing for people that are underprivileged and all this. And so they take and they appropriate a bunch of money from the Federal Reserve against your property rights, as we've seen in that congressional record, against your property rights, your sweat equity. They appropriate that money, then they turn around and they create an NGO, non-governmental entity, some kind of nonprofit, right? And that nonprofit's put in charge of creating these housing programs for the less fortunate. And guess who runs those NGOs? The same politicians that are appropriating the money, or their family members, or something like that. And so they run those NGOs. They're allowed to charge up the wazoo because it's all just taxpayer credit. And then they funnel it through their NGO back into their own pocket. That's how it's done. Right? So the name of the game is fleece the taxpayer, obviously. And what it does is it enslaves you. So mortgage, let's take a look at mortgage. So this is the last little piece I want to go into just to make the traffic code and everything make sense. So you see this, it represents mortgage and all the homes and other property of the people of the nation. So every single Federal Reserve note printed represents your indenture, your slavery. Okay. And so if we go over here and we take a look at the law of mortgages as defined in West Encyclopedia of American Law, we're just going to, and this is a great resource right here. It's called the Free Dictionary, and you can click legal and it gives you not one definition, but a bunch of definitions from different law dictionaries. And this one's West Encyclopedia of American Law. And it says that the lender, right, the lender being the Federal Reserve, was entitled to not only payments of interest on the debt, but also the rents and profits of the real estate. Okay. This meant that as far as the borrower was concerned, the real estate was of no value, that is dead, until the debt was paid in full, hence the Norman English name, mort, dead, gedge, pledge, dead pledge, right? So that's why the judges were, but you're literally civilly dead. You've been mortgaged. You're dead. To the law, you are dead. You have a trust relationship with your own body, even, okay? You only have equitable rights and you're told how to use it. And that can only be adjudicated in equity, not law. You're dead to the law. You're civiliter mortis, it's called. Civiliter mortis means dead to the law, civilly dead. It happens to bankrupts and it happens to felons. Well, everyone is an enfranchisement of a bankrupt principal, the U.S. corporation. Okay? So the rents and profits, how did they secure that? Well, that's why they created the Social Security Act. It created a public trust account number, right? Well, that links to the public trust called Social Security, that acts as the underwriting trust for all of the other commercial paper they want to generate. Now, I know I use some lawyery language there, and I try not to. I try to keep it generally digestible. But what that means is, say you register your car. Well, first of all, you get the Social Security number. Now, everything that you register with the government's going to get tied to that number. Okay, and that number acts as the surety for the public debt for the whole operation. So, say you register your car. Right? Well, first you have to get a license. How do you get a license? Well, it has to be tied to your Social Security number. Okay, cool. You get the license to get the car. Now you got a car and you have to register it, and it gets tied to your license, which is tied to your Social Security number. Now there's an account number called commercial advertising. It's a license plate they put on the back so that the cop can pull up all of your information linked to that primary account. All right. And everything. And now with Palantir and the stuff they got in these cop cars, a whole bunch of other, they can look at your bank account, your payment history, all sorts of stuff. That's what they want. That's how they're setting this up. Absolute control and surveillance. So then the cop gets behind you because now, remember, the property's registered. You gave it to the government. They have the superior interest in it. And so they require you to be hired by them to use it. That's the licensing, right? A driver is one employed to conduct a coach or carriage. So the state hires you. And then now you're subject to the motor vehicle code, which is a commercial code. Okay. And so if you're not using the property the way that the administrator has told you to, the DMV, Secretary of State, whatever your state has, the way that the state administrator has told you to, the cop can then create a state of peril, right? By flashing his light, siren, all that stuff for no reason, pull you over the side of the road and create an attachment to your trust. So he's allowed to link to your license number, which is linked to your Social Security account number, and then create a debt obligation. Well, that debt obligation is just as good as any other debt obligation in this system that uses debt as currency. So the court's generating its own unregistered commercial paper and then selling it to private investors. That's one way they harvest you. The other way that they harvest you is through the income tax and all that stuff, right? And appropriating money against your estate for your quote unquote benefit or the benefit of others, because it's pretty much a communist situation. Neo-feudalism is communism. And so now you've got to pay for these poor people and these people that make bad life decisions or have 25 kids with 25 different daddies and all that stuff. You get to pay for all this, right? Because daddy government says, you know, you've got to share your hard-earned property, right? You've got to share it. And so they appropriate money against your estate to create these welfare programs. And then these welfare programs are then leased out to NGOs, also controlled by Congress. And then they charge unbelievable amounts of money to carry out their purpose. And then they funnel it right back into these congressmen and women's pockets. And now they're just cutting to the chase. Right. That's not even they're just with the Somalis. They're like, OK, these welfare programs are going to borrow against your estate to create these learning centers for people that aren't even Americans. That's wild. And these people actually hate us. It'd be one thing. It wouldn't be much different for me. I don't know about you guys. It wouldn't be much different for me if they didn't hate us, but they do hate us. And they think that we're a joke. Right. And so they're funneling it through these Somalians right back into Governor Walt's pockets, right back. And trust me, I'm not political because it's happening in Republican states and it's happening. They're all corrupt. It's all one big mob, one big gang. That's it. They're a bunch of corrupt, crooked aristocrats. So, who use their knowledge of the law to manipulate everyone else. So I'm going to take a look, before I shut this down, I'm going to take a look at a few comments, questions. I'm not going to go too far back. I just want to see what you guys are saying. So we got Cameron Maxwell says, Constitution of no authority, no treason. Lysander Spooner, the Constitution. Yep. All them has no inherent authority, give up the status mindset and become free. That's kind of the idea. So I have a little bit of a different opinion about that just because I'm practical. I do agree with most everything Lysander Spooner says or has said that I've read. But here's the reason we started with any government at all. Because obviously government is evil. It is evil. It's necessarily evil. It always seeks to increase its own power at the expense of those that it governs. It is a gang. It's the original gang, okay? Created by Cain way back in the city of Enoch. It's the original gang. And trust me, not having government would be absolutely the most fantastic thing that could ever happen. But in order for us to not have government of any kind, we'd have to have perfect internal monarchy. So let's entertain that for a moment. Say everyone knows how to conduct themselves properly, defend themselves if somebody else doesn't conduct themselves properly. Yeah, you could probably do that, even with a little, criminality, or even a decent amount of criminality in society, because if people can defend themselves and have the right to defend themselves, it's going to take care of itself. Now, if that were the case, the problem is all the other governments. And this is why I say government only exists because government exists. That's it. Government's only necessary because government exists, right? There's a whole bunch of other gangs all around the world. So say we didn't have a government, you need to form some sort of structure, hierarchy, agreement between the people in the community to agree to come together and fight with one another against these other governments who, once they see you have no government, they're inevitably going to come over and try to take you over. That's just going to happen. It's especially wrong. So now, say you do form that. What the hell is that called? That's a government. Right? You've got to enforce this agreement. You've got to make sure everybody does actually do what they said they were going to do in the agreement and come together and defend each other. And that creates a form of government. That's the thing about it, right? And trust me, I'm just as much of an anti-statist as you guys. I really am. It's just the practicality of it. You understand why the founders set it up the way that they did, the good ones anyway, under the Articles of Confederation. That was about as close to a perfect government as you could get. And I'm talking about the Articles of Confederation, not the Constitution. That was about as close as you could get to the ideal government in this world, if you have to have one. And you have to have one because other governments exist. And that's why our government was originally beneath us. They work for us. And I've shown that in the Supreme Court cases. Not only that, but they don't partake in the sovereignty until they return to their private status. So as government officials, they are indentured. And that's how it was originally set up. Now they think they're your parents. Okay, that's the problem. So that's my take on government. I don't expect everybody to agree with me. I've read a lot of books. I'm sure you could probably figure that out. And there's this one great book called The 5,000 Year Leap, and it was Constitutional Law 101. Read it years ago. And he explained kind of to that effect why, it pretty much outlined what I just said. It's like, we don't want a government at all. There's no need for it. The government is the family. The family governs itself and conducts itself, civilly in accordance with the law that's not written by men among, society. So, and that would be ideal, but the problem is the other governments. That's the problem. And I think that's why they even chose the very limited form of government we had initially, because I think a state of nature would be better. There's also the facilitation of trade. You've got to have weights and measures. Otherwise, you have to have a completely agrarian, which Thomas Jefferson did say this, you have to have a completely agrarian society, meaning everyone has their own farm. That's the only way you could truly have no government, if you're entirely self-sufficient, because otherwise you're going to have business deals and commerce. And if you have that, then you're going to have something to enforce and make sure people honor their contracts and all that stuff. And that's kind of where you get into government. You know what I mean? So I know it's not something people like to hear, and I definitely wish it wasn't the case, but that's my opinion. All right, let me see what else you guys said. we have, okay, yeah, so that's why in court they want you to have an attorney. Must have been talking about when I was talking about the attornment. But under Corpus Juris Secundum, Volume 7, Section 4, if you use an attorney, you're awarded this. Absolutely. Yeah, that's absolutely true. That's why they want you to do it, because then you can't challenge jurisdiction. You've already been attorned. An attornment has already taken place, and your homage and loyalty is with the court. So, no, it's not hopeless. Yeah, what does I say? Iris Ruiz. Yeah, it's not hopeless. Actually, I think we have a good shot at turning this around because so many people are awake. So many people are awake. And here in the United States, and I feel sorry for you if you're anywhere else, because the one thing we still have is our weapons. So that's why they only push so far and then they back off, because they, at the end of the day, they know they wouldn't win an outright conflict with us. So, all right, let's see. Pat says, from a state patrol to being paroled by the state, it's a slave farm. Absolutely. A state of parole got you. From a state of parole to being paroled by the state. It's actually true. Yeah, it's a good way to put it. Losing my voice a little bit here. Doing jail time and then getting out on parole is called double jeopardy. Well, actually, the way that they circumvent that is the parole, you're not actually released. It's a conditional contract that you enter into. Basically, so they give you a min and a max. And I know they don't do that in every state, but basically your consideration for being released early, or your consideration for the contract is being released early, and their consideration for the contract is to maintain supervision. So it's not actually considered a release by the Department of Corrections. It's considered a decrease in supervision. So how about that? Stupid. Let's see. He says, yes. Ayas Ruiz says, yes, but Yahweh is just. He will not allow this to continue. Well, that's why so many people are waking up. Honestly, I think it's something that they knew was coming, because the same type of thing happened just before the revolution. Look into it. If you don't believe me, it's called the Great Awakening. It was. And then there was a second one in the middle of the 1800s, the second Great Awakening, and it's happening again. They know. That's why they had the last, the thing they just did the last 5 years planned. That's why they enacted it in 2020. And they were trying to stop this from happening, but they failed. And I think there's too many people awake for them to, they're scrambling. Let's just say it's a race to the finish here. Let's see, what else we got? Still not banned. Oh, is somebody trying to ban you, Grammy? You guys were fighting or something? Yeah, leave some comments. Let me know what's going on with that. Let's see here. We got the government are trustees of a trust, and they're committing trust fraud and should be in prison. Yeah, it's fiduciary malfeasance, 100%. Absolutely is fiduciary malfeasance. And you're right. That's a big thing that people need to understand is government is a trust. Yeah. All their statutes and codes and stuff like that are for regulating the trust property and the trustees of the trust. If you're outside of the trust, then it has nothing to do with you. And that's why they pulled everyone into the trust. Well, here's how you put it. You can be a part of the trust, but when you're a grantor of the trust, and a trustee, it's an entirely different position than being a trustee that was created by another trust, which is what a 14th Amendment citizen is. So if you're a state citizen, you're considered a grantor of the trust, right? You control the terms of the trust and you hold the power. And if you are a trustee under the 14th Amendment, if you're a U.S. citizen, then you are a creature of the federal corporation and entirely subject to the arbitrary whims of Congress, who continually change the rules of the trust. So that's kind of how that works. Old age protection racket, absolutely. Oh, damn, you guys are fighting. Hey, Raj is a cool dude, man. You guys probably just have a disagreement on something, but Raj is cool. So we need a band of robbers, thieves, and murderers to protect us from people. No, and see, that is the whole logical fallacy of it, and that's why they tried to find that's literally the struggle of how this government was set up originally as a servant of the people. You realize that this republic is the only one in history that we know of, in recorded history, that has the people enshrined as the sovereignty. And not only that, but the right to abolish the government enshrined in the fundamental framework of it. That's nowhere else in the history of man is that the case. And that's why, because that exact understanding. It's Thomas Jefferson, I believe, said that the two greatest threats to mankind are criminals and government, right? So we must bind the latter with the chains of the Constitution so they do not become a legalized version of the former, which is criminal. Yes, it's a common knowledge. That's what's so crazy about people going, oh, you're a conspiracy theorist. You don't trust the government. Historically, people have known not to trust the government. They know that it's evil, and they know that if given the opportunity, it will take from them and end them. 100%. It is the beast. It has always been evil and corrupt since the very first government was ever made. Of course it is, right? But again, the issue is, and you can see the prudence in the founders of like, okay, we'll say we have no government, right? But then how do we mount a defense? That's the problem. You have to actually have trained, military trained in combat, because if you don't, then you're going to lose. That's just, I guess you don't have to, but you're going to lose because these other countries, these other governments, especially the totalitarian ones, that is their main focus, is military strategy and training and control, population subversion, all that stuff. You know what I mean? So that's the catch-22 about it. But I mean, I do agree with you. That's the whole reason about why we need to be responsible for spanking their ass when they get out of line. That's why we have the Second Amendment. That's why we have the First and Second Amendment, right? As Dave Chappelle says, you got the First Amendment to speak out, against wrongs of the government, stuff like that, right? And you got the Second Amendment in case the first one doesn't work out. Truer words have never been spoken. So, don't lose hope, pray. Let's see here. Hear us now. I'm trying to see if we got any more questions, or, all the comments are pretty funny, but let's see here. You have a certificate of title on your automobile. If you own the vehicle, you would have the MCO. That's absolutely right. So that would be the allodial title. Certificate of title is just evidence that a title exists and you have an interest in it. But see, you have the inferior interest, meaning you only have the right of use of the property, and the state holds a superior interest in it. So that's how they can make you adhere to the motor vehicle code. And the fact that they require you to be hired to use it, that's what a driver's license is. The state is literally hiring you. Look into the history of the motor vehicle code in your state, and you'll come to the same conclusion. Look at what the word driver means. Look at what the word operator, the origin of that is a workman, right? Operatio. Look at what the word motor vehicle means. Title 18, USC, right? Look at the Motor Carrier Act. That's how they expanded that the entire scheme to regular people, because it originally started in all states for commercial trucks, commercial automobiles. That's the licensing and registration started with them. And then they slowly expanded it to everybody and slowly pulled everybody into commerce. And now driver is one employed to conduct a coach or carriage, right? For hire. That's what it means. Employed. And if you look up employ, it's being paid to do something. It's being hired to do something. That's what employ means. So what does license mean? Well, it's permission to do something that would be otherwise unlawful. Well, what's unlawful about engaging in commerce on the roadways? Well, under the Trading with the Enemy Act of 1917, as amended by the Emergency Banking Relief Act of 1933, Section 5B, that is, made using bills of credit and all that stuff. Basically, it made commerce criminal, requiring a license issued by an agent of the president. So I can't remember verbatim exactly the wording used, but that's what it is. See, the original 1917 Act excluded the territory of the United States, territorial jurisdiction of the United States, as not being under that act. And then the amendment in 33 changed that to include everyone within the territorial jurisdiction of the United States. Right? You basically have to have a license to engage in commercial activity. So the state takes it upon themselves to hire you to use their property, which once you register it with them and you put the state's advertising on the back, it becomes public property. It becomes public conveyance. And that's specifically what a driver is somebody who operates public conveyance, as you look into the history of that word. So driver used to be the guy that sat up front of a public coach and would steer the horses around for hire for the, it was a public coach or carriage. So anyway, all right, let's see what else we got here. It says the street is correct. No. With what they got away with the last 6 years, with all due respect, that is hard to believe, Ryan. They won't directly take us. Well, if they would, okay, I'll put it to you this way. In other countries, they would. But in this country, no. And that's actually evidenced by the last 6 years and the fact that, so all states, if you didn't know that everyone, or all nations rather, if you didn't know that all these nations were controlled by the same people, one centralized hub of authority, well, you should know that now, because every nation in the world acted in lockstep. Even the corporations acted in lockstep to implement the same arbitrary policies around this whole thing. And you guys know what I'm talking about, the 6 foot distance, the mask, all that stuff. Every state did the exact same thing. Now, the only thing that differed from, or state, nation, same thing, states or nations. The only thing that differed from nation to nation was the degree to which they implemented it. So for instance, over in Australia, they had drones flying around with facial recognition, cross-referencing people's face with their registered address and seeing if they're outside of their quarantine zone. Drones, literally. And if they were outside of their quarantine zone, they would send a bunch of cops to go arrest them like they were mass murderers. There was a couple that was honeymooning in Australia, and they went outside their zone for their honeymoon, and they literally sent like 10 cop cars and a helicopter. I watched the video. It was absolutely insane just for going outside their quarantine zone. You know why? Because Australia gave up their right to bear arms. You had, England, you've seen that was fairly tyrannical. Canada was terrible, and still is terrible with their tyranny. And why? Because you guys all gave up your right to bear arms. Now, in the United States, they pushed it, and they pushed it really far in the commie states like Minnesota and California. They pushed it really far because they know all those people are against guns. But you notice that didn't happen so much in the place where they're well armed and they're willing to use them. And that's what I mean by that. They're not at the point yet. Now, if they get AI set up, the AI governance, and they actually get like robotic police and all that stuff, yeah, they'll definitely do it then. And that's why we have to stop this before they get to that point. They'll definitely do it then. If it's like iRobot scenario type, you know what I mean? Yeah, they're for sure. For sure, because now they can just manufacture soldiers and policemen, and then the policemen and soldiers have no conscience, no heart, and they'll carry out whatever orders they're programmed with. And they can just, it doesn't matter if you break one of those. They don't care. They do care if you break one of them. So, you know what I mean? So I do think they care now, but if they get this whole AI and digital ID and all that stuff set up, yeah, then we're screwed. It's not to enforce people that don't honor their word. Government is made for that's definitely who's attracted to go to. So, okay, again, I'll clarify this. Government is not supposed to be in charge of us. Government's not supposed to be able to legislate against your rights, your unalienable rights, okay? So government's supposed to provide utility and to handle the things we don't want to do on a day-to-day basis, like facilitate trade, deal with foreign nations, stuff like that. The government's there to provide court as a utility. Now court has become a weapon. Court is not for the judges in the state to bring suit against people. Not in this country. The court is there for us to use to deal with disputes with each other. And the whole reason court exists is so that we don't have to resort to violence. That's it. Civilized warfare is what court is. And it's basically so we don't resort to violence. That's gentleman's warfare. And it's just supposed to be a utility. I'll give you an example. The only way you could come under the jurisdiction of a court before in the original republic was you had to hurt somebody. Then that somebody had to go to a magistrate with a signed sworn affidavit that you did hurt them. Okay. And they had to swear on it, and it had to be signed and attested to by a witness. Only then could they move to bring you into the court. Now, when you got into the court, the judge, which is not a judge, it's a magistrate, justice of the peace. The magistrate is not the tribunal authority. It does nothing but point out facts of law that apply to the case. And that's what charge originally means, right? The charge they use now the contract definition of charge is to render an estate responsible for the performance of an obligation. But the other charge under common law is just, hey, if that's true, then that means that he did this, and this has been upheld in this case, and it's a violation of this fundamental right. Okay, boom, that's a charge. And the magistrate's not the one bringing the charges, and the magistrate also doesn't decide whether or not the person's guilty in common law. You know who does that? The jury. The jury is the sole tribunal authority, and that's composed of what? The people. So that's why I'm saying court is a utility that's supposed to be used by us and not by them. That's a fact. He said I'm a wild one, huh? Yep, that's true. Story will continue. Old Testament. Let's see. So you say our weapons keep us safe, but with technology they have now, one person can take out thousands and millions, so we need to hurry. Well, I'm with you on that, Verity, for sure. That is the problem. That's yes, technology is leveling the playing field for them. That's what it's there for. That's why they're using it. No question about that. Let's see. What percentage? Well, I do actually have someone. So what percentage didn't mask up? Slaves live under the sun, asks. He says, what percentage didn't mask up in a rural place of right learning population? I was one of 3 people out of 100. Well, yeah, initially. So here's how this went down. So as awful as that situation was, which I'm not going to say because we're on YouTube and Facebook as well as Rumble. I could say if we were just on Rumble, but the way that situation went down is, yeah, initially people were horrified because they were sleeping. They actually believed the government, and they didn't think that the government would do anything like that, right? And over time, as everything started to fall apart and all their lies started to fall apart, and there were people like us out there exposing what was going on, the people started waking up. And COVID, while it was horrible, also has a silver lining, right? It woke people up. It woke people up to a lot of things. I said it, didn't I? Whatever. Anyway, it woke people up to a lot of things. And so it kind of backfired. It really did. It backfired on them. And I agree with you. I was so hopeless for a while when I seen how many people just blindly followed whatever. But then after about a couple years into it, people really started to push back. They're like, hold on, because it wasn't going away, and they were pushing it further and further and further because that's what it was there for. They wanted to see how far they could go with it. And it had the effect of actually, I'll give you an example. So my cousin, right, used to be like, you're a crazy conspiracy theorist, blah, blah, blah. It's back like 2018, 2017. He's like, dude, you're crazy, man. I can't believe you believe all that stuff, right? Okay, cool. I would show him literally all the news stations saying the same thing at the exact same time. All news is scripted. And they'd be like, okay, that's weird, but oh, come on, man, that's not really happening. Then that happened. 2020 happened. And about a year later into that, I get a call out of the blue from him. And he goes, hey, cuz, you were right. I'm like, what? He's like, I'm sorry, man. I'm sorry I gave you shit about that. You were right. You were absolutely right. There is a group of people trying to take over the world. I said, yeah, dude. Yeah, there is. And that's happened to a lot of people. So many people. Right? So it's kind of like a double-edged sword. It's awful, and there's still the fallout from it is awful and will continue to be awful probably for a long time because of how many people went and got the thing, you know. But it did serve to awaken humanity to a large degree. And, you know, maybe that's why they called it, you know, they did it in 2020 because 2020 is perfect vision, right? So, all right, guys. Well, let's see, criminals, government, they're the same. Absolutely. Why am I asking about them and not you? No, I'm not asking anybody outside of you. Yes, it's relevant to talk to you. Why are you flipping out? I'm way up in the comments, and that's holy crap. Well, I guess we'll read this super chat from one of the jurists. This is Eddie. Hold the line, G. He says that was supposed to say Happy New Year. Okay. Thank you, brother. Appreciate that. Happy New Year to you as well. And also, I hope everyone had a Merry Christmas, Happy Holiday, whatever it is that you celebrate. I celebrate Christmas, so because I'm Christian. But yeah, That's so. And Grammy, I don't know what kind of beef you have going on with whoever in there, but I'm not mad at you. I don't even know what's going on, so I am talking to you. So he says, I know sovereign before FE. I've no sovereign before FE. I'm Scots. It's interesting. I'm also Scottish. I have a lot of Scottish blood in me, so it's pretty cool. And thank you, Alflees Gutra. Gutra. I always have trouble with your name, man. I don't know why I butcher it. Apologize. But Happy New Year to you as well, for sure. And definitely thank you, Eddie, and Happy New Year to everyone else. And holy crap. Is there 2 of them? There's 2 of them. Wow, dude. Thanks, man. Can you get a refund on one of them? I get it. It was supposed to say Happy New Year. I got you, man. Thank you. Very much appreciated. But yeah, for sure. All right. So with that, guys, I hope I hope everyone gained something from this. I mean, it really only works one way. Law only works one way. Okay. And it can only be subverted one way outside of obvious force, war, so you can either conquer a nation to enslave them or you enslave them with debt. That's it. But the true definition of slavery is not having any autonomy over your own property or even just absolute autonomy. If you do not have absolute autonomy over your property, if you can't go down the road in your automobile without a little slave plate on the back of your automobile and a little slave card in your wallet, right? And then you have to follow all the slave rules, right? That you're not free. You're not free. That's not at all, because one of the most fundamental aspects of liberty is the right of locomotion, the right to move from one place to another unhindered, unencumbered, right? So that's pretty much how it works out. Is your relationship to your property determines your status. If you have absolute ownership and absolute right to your property, then you can enforce those rights at law. If you do not, you only have an interest in your property, and it's an inferior interest, then you're a form of slave. You're an indentured, right? So that's what it boils down to, and the way they do that is through debt and dependency. Dependency is the biggest thing, because then the debt. Making you dependent upon them, as Blackstone had said, right? You come under, you have to subject yourself to their will. So with that, I hope everyone has an excellent evening. I will try to do another stream before the new year, but I'll be definitely doing streams regularly again after the new year. I've been focusing on the shorts. They seem very effective at delivering, concentrated red pills of information to people, and seem to get the message out there pretty far and wide. But I definitely am going to get back into doing regular live streams here, if not before the first of the year, most definitely after the first of the year. So I hope you all have a happy new year. Enjoy yourselves. Don't end up getting kidnapped by some pirates if you can help it. And we'll see you guys next time. Have a good one.